trusts by moving titles in commerce. Featuring NTT, New Trust Technology. Presenting your host, Christian Walters.
Welcome, everyone, to this Tuesday, March 9th edition of Money, Banking, and Trust. I'm your host, Christian Walters, and I started the recording, so this is just a general question and answer night, so if somebody's got some questions, just bring them on.
Yeah, I have a question, Christian. This is Lloyd.
Hi.
Hi. In trust purposes, it says here that except for the special case of honorary trust, the trust must be either private or charitable. Does that mean then that they have brought us, they brought the Constitution or the Constitution? Well, yeah, it would be the Constitution, our Constitution. Have they brought that into a private trust? Is that what that is?
I would say it's more of a statutory trust because, that was created after the United States under statutory law.
Well, then, how does private part of this enter? Well, how do we know then if we're in? I'm confused now because I thought that a trust could be public or private.
Well, I would claim the law form, say, of 1776, say Declaration of Independence, and since that was pre-United States of that was pre-statutes and codes. So now, according to the International Hague Convention, under the rules, I forget what chapter it is, Chapter 2 or Article 2 or something like that, it says that the grantor has the ability to set the law form. So I'm going to set the law form for 1776, pre-statute code, pre-statutory United States.
Okay, so then that's how we keep it private.
Yes, uh-huh.
Okay. All right. Well, that was something I'm trying to wonder. Okay.
But really, how you keep it private is you're going to put a protective order on your CCI information or your trust-proving documents and make sure that you bring it in chambers.
Right.
That's
something that I'm not clear yet on how to write a text.
Well, I'm going to put an example up there. I've got an example of a protective order from the federal venue. I was going to put it up on the website. I was going to do it last night, but I had some problems. I couldn't get it up there. I was going to put a protective motion and a protective order up there to give an example of what to go by. But then if you go to a local law library in your state, and there should be a book, I believe it's called Benders, and they may make some other ones, but all they are is just books of forms. And in there you're probably going to find a protective motion form.
Okay. I know that we had talked about that once more, but I don't have a law library around here. I've got to go to another city to get one.
We've got some guys working on some, might want to contact Eric or JC. They might want to share what they've been working on with you.
Well, I know that I had talked to Eric, and he was interested in having somebody that knows more than I do to work with him. So I don't know who else to contact. It's the only one that I've got hold of.
Eric, Floyd, is that you?
Yeah.
Floyd, yeah. I've been working with a few people recently, and the train's starting to get a little momentum on that. And I know everybody is interested in getting the protective order. So it's going to be a little bit of time before I think we actually have something we can show to everybody else. But rest assured, we are working on it, and I think that there is going to be something soon.
Well, I'm gonna have to go to a larger town to get to a law library and see if I can look up something on protective orders in the law library, because I would like to find something, and then maybe I could add to the.
Well, you could start in your local internet there and just go to your local rules of court and look under your discovery rules section, because that's where a protective order is coming out of discovery. Like in Florida here, it's Rule 1.280, Section C, number 7. Section C is protective orders, where 1280 is really discovery. But under Section C, that's protective order, and number 7 talks about trade secret information or confidential commercial information.
Okay.
And that
May I offer you something else?
that you can get off the internet.
Pardon me?
You could get
Well,
that
may
off.
I offer you
the internet.
something? Oh, I'm sorry. Go ahead, Christian. I apologize.
You could get that off the internet. You could check out your local rules and find out where discovery is, and find out where the protective order is in discovery under your local rules.
Okay, because I know I put in protective order on Google, and I came up with some things, but they weren't anything that really helped.
Yeah, just do a Google for your local court rules, and when they pop up, then just search in discovery rule, and then go into discovery rule, find protective order, and you'll see under the protective order the CCI information in there.
Okay.
I have something to add to that.
Go ahead.
Okay.
And what I did is, first thing I want to suggest everybody do is go to Federal Rules of Civil Procedure 26C, and then read C, and then read G. So they'll have the foundation of the rule that every state is basing their rules upon. And I'll repeat that again for everybody. That's Federal Rules of Civil Procedure 26C, and then under that it's going to be G under C. And then also go to Google and put in Protective Order Confidential Commercial Information, and then do a Google search for that term, and do the Google search for Protective Order Trade Secret Information, and look at the different pleadings that people have done that are posted on the internet to get an idea of what these attorneys are doing out there and the kind of elements and the way they're putting these things together, and that'll give everybody a real good foundation for the kind of things that we need to put into ours.
Okay, so you put protective order. What was the first part on Google? Protective order.
Confidential commercial information.
Okay, CCI.
Yeah, but spell it out.
Okay.
When you do the search, make sure you spell it out. And then the second one is protective order trade secret information, and make sure you spell that out. And there's all kind of pleadings all over the internet that you'll find.
Okay.
Okay, and one that I found that was very good is Walsh versus Apple, and another one is for Oracle. A U.S. attorney wrote that one, and there's some good information that we can study and glean from that.
Okay, that was Apple, huh?
Apple versus Walsh, or Walsh versus Apple.
Okay.
And the other one was done for Oracle Corporation.
Oh, okay. Oracle Corporation.
And since we're on the subject of protective orders, I have a question for you, Christian.
Okay.
Okay. Now, Michael and I were talking about this earlier today, or maybe it was Terry. But either way, we were talking about when we put one together. And Michael, if you're on the call, please feel free to and Terry, if you're on the call, please feel free to jump in on this if I miss something or if I don't get it right.
Okay, I'm here.
Okay. And we were talking about this, and what we were trying to figure out is for one thing, when we do a protective order, do you really feel like there's any need for us to include case law in it in order for the judge to recognize something with some force to grant it, or do you think we can do it, get it to stand purely on the either the federal rule in the federal court or in the state rule in the state court?
Well, if you notice the way their whole system is set up, it's always an NOI followed by an SOI or a rule. So if you're going to make a claim, say protective order claim, and then you're going to come in with the SOI, and that SOI would be either the rule that you're using or maybe a case site to support it. Everything works with an NOI SOI.
Christian, I have a question for you in using cases in your case or case law in your case. I was listening to another call that was from the other day, and Liar, who I'm sure most people on this call, a lot of them are familiar with, he brought out the point that if you're going to cite case law in your case, there's a certain procedure that you have to follow to get the judge to recognize it and give it jurisdiction, so to speak. And what he was saying is you have to
state. That's
pardon me?
outside of your state.
Okay, so if it's inside your state, they would readily accept it?
Yes, right.
Okay. In some cases where you have mortgages or cases against you for foreclosure, it may be outside of your state?
Yes, you can make reference to rules and case sites outside of your state where your action is located, but you're going to have to judicially notice it, and usually do that only because you don't have local case sites to support it.
Right. That's basically what he was saying. Okay.
Well, what if you have a federal case that you could cite? Would that help?
Well, any case that's in federal could be cited. It wouldn't have to be judicially noticed because the court should take automatic recognition of it.
Okay. Can't you cite a case from another state under the Savers Suitor Clause?
Yeah, but you'd have to tie it in some way, make sure that you got it connected. So you're probably usually going to have to judicially notice the Savings to Suitors Clause.
Yeah, what he was saying is you have to get a certified copy of it out of that particular case, the first page, and then the judge's signature, and then enter it into your case, get it certified, and then pull it out certified in order for it to be noticed or allowed.
If it's a local state, you could make reference to outer state sites, but you'd have to judicially notice it. Or if it's federal, you could do that, and from any state, really, under federal venue.
Okay, Eric, you were saying?
Well, I was, so what I'm trying to figure out is when we're putting these protective orders in, do we need to put case law on them, or is that purely optional?
Well, I think that you're probably going to have some kind of way of supporting your NOI claim for protective order, so I would probably put a case site in there to support it from your local case, your local state, wherever you're coming from, if it's a state case.
Okay, so that's going to put us to the task of finding both federal cases for the federal.
Evenly.
Yeah, because you have to give them what they're accustomed to seeing, their form, their process, their procedure, and that's what they're accustomed to. Because you just can't state a claim. I need a protective order unless you got some kind of SOI or material fact to support it. And then the way I've noticed everything is set up, the ones successful cases, they always got an NOI supported by a case site or a rule or some kind of SOI to support that NOI.
So that answers my question. We in order for us to do these protective orders, we need to come up with good case sites to add into them.
Yeah,
either in
the
state or in the federal.
Yeah, if you go over O'Connor's, if you check O'Connor's is spelling out stuff in there.
Okay, and if we could use a federal case that we can judicially notice for the state, and actually use one federal case for every state when we bring it all into the state, right?
Yeah, but then you have to judicially notice the federal to bring it into a local state action.
Right, I'm aware. But that might be the simple way to do it instead of everybody have to find a separate case for their different states, right?
Yeah, but they usually like to see local states sites and then go to, say, another state or a federal when you don't have a local state site to support it.
Okay.
That makes sense.
Now, Terry, when we were talking earlier, we had a couple other things we wrote down that we wanted to find out about tonight, if you're on there.
Yeah.
With the notes we made.
Yeah, we wanted to go over basically all the ins and outs of what a special deposit is, maybe in different scenarios, what they would be, and how you actually make a special deposit.
And I'll add to that, a little while later, Michael and I were talking, and what might be a great study would be what actually is the moment that a special deposit takes place when it comes to doing our property taxes. And then the other notes that we took that we were thinking about for discussion, what are they, Terry?
About doing the UCC-1. It's one of the questions I have about persons entitled to file a record and whether that's even pertinent since it is on the statutory side.
And were there other things?
Slips my mind right now, but I may think of it.
Okay. And if anybody else has anything that maybe we could lead the call with to kind of prepare Christian for conversation, if anybody else has anything that they want to talk about tonight, please let's maybe set the tone of the call now.
Are you on tonight, Tony?
Well, Christian, one of the things that we were talking about back and forth was maybe focusing on going for the main trust, expressing the main trust, and not be so distracted by all these little side issues that may or may not be effective.
Right. But I think if we keep it on a model, the model could be applied to, say, the main one or any other sub-trust or anything else.
One of the concerns we have also is if everybody starts jumping out there in their jurisdictions and trying to apply this trust technology and throwing up red flags in the process where those that are controlling the system are going to possibly throw up barriers that when we are ready fully to go after the main trust, that it won't be available to us.
Yeah, that's true.
Kind of like flying under the radar, and once we get into the main trust, then they don't have any action against us because we are non-resident aliens and out of their jurisdiction and have the wherewithal to help anybody we see fit.
Right.
And then I rebutted that with, well, we got to put some of this to action to understand how we're going to conduct ourselves in different situations. And I said that whether it be a mortgage case or a court case, whether it be a traffic ticket or whatever, we still need to get in and do some of these things so we know where we stand and how effective it's going to be on a small scale basis before we go to the big scale.
Again, if that raises a flag that causes them to look a lot closer at anybody trying to do trust, they may intervene in our efforts to do the big one, so to speak. And now all we have left is all of this little stuff that they'll eventually shut down too, just like they're doing in debtor creditor.
I don't think that could be possible if they're truly operating trusts, they have to operate according to trust law. And
ideally, I agree.
So I don't see how it doesn't matter what kind of flags that we put up as far as if we're operating according to trust law, they're going to be stuck with trust law too.
At least we're on
with them. When it comes to doing something like getting an apostille, like Christian introduced originally, if it has nothing to do with trust law, but yet it's pertinent to us getting to our main account, they could stop that totally disregarding or not pertaining to trust law.
I think somebody came up with a workaround with that. They mentioned that we could attach an allonge and everybody could be a signer on the allonge and do it as a class action thing.
Mm-hmm. I don't know. I'm just concerned about them catching wind of what we're trying to do with regard to trust and how important that is and what a vast impact it will be if they are in opposition to it.
Right, yeah. So there is that possibility. And we do have a dynamic person that we're, fighting, doing battle with, so it more changes, counteracts.
And couldn't we initiate that effort for the main one, and while we're waiting on that to, for lack of a better term, cure, be working on all the little small potato stuff?
Yeah.
In other words, this is Michael. In other words, working on all the documents. I mean, everything that you said, the private order and everything, the protective order, this is very important. But the main objective, and this is what your original teachings were at the beginning, was getting into the main trust and then distributing those funds. And I just see it going off where everyone has their individual issues, which are important. But, if we sabotage by doing all this trust stuff, going into the courts, they've already done that with the creditor-debtor. And I know it's a different situation, but they could go ahead and put obstacles in front of us. And, a lot of the people on the call tonight that have been on the call from the very beginning feel the same way. I don't know if you feel that way, CW.
No, I've always focused on the main thing because that's the really most important one. If you pull the main root out, the rest of all the issues just dry up.
And that's what we all feel, and it just, with everyone becoming aware of your teachings and being aware of it, they're more concerned about their individual issues, which are important. I don't want to discredit that one bit, but the thing is pulling the damn root out. And then we'll be able to help anybody that we can and bring other people in under the umbrella.
Yeah, we're getting background noise, so if you're really not speaking, why don't you press mute out?
Yeah, it's not much longer.
So, Eric, some more you were talking about?
Well, one thing that I'd love to have is a lengthy discussion on special deposit, because I think that if we talk about a few different scenarios, so we all have a real good feel for when we actually create trust in different situations, let's say in a court case, let's say with our property taxes, with a mortgage, with privately between us one way or another, whether, let's say, I take on a business partner and we make an agreement, for example, and whatever other scenarios we can talk about, I think that would really help everyone to have a much better foundational understanding of trust in its complete form, because we're all getting more and more knowledge about the steps. But I think very few people really have internalized the understanding of when the moment that it actually happens in different situations that we're already involved in. So whichever one you want to lead off with, let's have some discussion about it, Christian.
Okay. Well, we're really talking about trust res, so we're talking about special deposit, talking about segregation. So there's the three main points, I'd say. And really, that's the formation of the trust, when you transferred res to the trustee. And I keep on going back to the Banker's Handbook, which defines special deposit. I read it last night, so for those that didn't hear it. But anyway, this is out in Section 19.02, Section 2C, the Bank Officer's Handbook. It says special deposit.
Christian, who's the author on that?
What's his name? Milton R. Schroeder.
Okay.
This is the, I think it's 1985 edition of what I have. I also have a 62 edition, I believe. States that special deposits may take on a number of forms. Sometimes they are a means of holding funds in litigation, trust funds, and cash securities of various types, such as deposits to show good faith in the case of contracts and the like. Attorneys maintain such accounts to hold funds for clients for whom they are fiduciaries. Special deposits are created by special contract between the bank and the depositor. In most instances of special deposits for the benefit of a third person, the bank becomes the trustee of the deposit for the benefit of the named person. Special deposits are often payable upon demand, sometimes upon terms, and occasionally they bear small amounts of interest. In many instances, such amounts are evidenced by certificates of deposit. So there's where the interest comes in, and also the certificates of deposit. And then we might want to talk about the certificates of deposits on the next section under D, which says that the CDs are instruments issued by the bank specifying that a certain sum of money has been deposited. And then my question is, why aren't we issuing CDs ourselves? So these certificates may be either negotiable, which is public, or non-negotiable, which is really private. So when non-negotiable, the bank simply contracts in return the amount for the depositor to the depositor plus any contracted for interest. So there are mentioned interest again. So if the certificate is negotiable, the bank agrees to pay the depositor or any person whom the depositor shall order or the bearer of the certificate. And when the CD is a non-negotiable CD, the debt of the bank is to the legal holder of the certificate and not to the original depositor. So then Black's Law, I believe the 4th edition, on the 4th edition revised, I believe it is.
Are you looking at special deposit?
Yes, I'm trying to find it here.
In my Banker's Handbook, I've got 3rd edition by William Vaughn, Thomas Stores, and it doesn't have anything about special deposit in it. Would there be a reason for that, I wonder?
What version is it? What year?
It's 1990 something. Let me see.
Yeah, probably by then they've probably taken that stuff out because that signifies trust, and they don't want you to know about trust.
Oh.
Because if you go to like the 62 version, you start seeing a lot of stuff in there. They're pretty loose with the knowledge at that time. When you start comparing it to the 85 version, you can see they're starting to tighten things up. And then if you got a later one, you'll probably see they've taken that stuff out completely.
Yeah. Yeah, this one goes back to 97. That's as far back as it goes.
Well, I lost my special deposit.
I looked it up in the 4th, and I don't have special deposit in the 4th.
Yeah, maybe it's in the 8th. I thought it was in the 4th, but maybe it's in the 8th.
I mean, I know trust deposit is in there, but not special deposit. But we could use special deposit and trust deposit interchangeably, right?
Yeah, that's what I was trying to point out. It says that they're really synonymous terms.
Yeah, here's in the 9th it gives the special deposits as a bank deposit that is made for a specific purpose that is kept separately, and that is to be returned to the depositor.
And the 4th says under trust deposit, where money or property is deposited to be kept intact and not commingled with other funds or property of bank, and is to be returned in kind to depositor or devoted to particular purpose or requirement of depositor or payment of particular debts or obligations of depositor, also called special deposit.
That's the one I was looking for. What one's out? That one's out of what again?
The 4th.
4th.
Under trust deposit.
Oh, okay, because I was looking under special deposit and couldn't find it.
Yeah, I couldn't find it. Special deposit's not there.
So it's under trust deposit, but also says that it's a special deposit in the definition. So it is in the 4th. I wasn't looking right.
I knew that's what you were looking for, Christian.
Yeah, thank you, Eric.
No problem. I just figured I'd give you a minute just in case you were going to come up with something else.
I'm slipping, yeah.
No, you're not.
But anyway, there's also case sites, they support those things also. Because this one's listed in Morello versus Broadway Bank and Trust Company of Patterson, 114, New Jersey Law, 167, 176A, annotated, 391 and 394. And then they're also making reference to seed deposit also. But the fact is that the trust deposit is also known as a special deposit. So a special deposit is a trust deposit. And it's all talking about trust. So here we were talking about special deposits. There's no trust wording in there, although it pertains to trust. It has to be a trust.
So, for example, if we take our property taxes when we buy our house, or it's granted to us by a trust, by a grantor, however we acquire the property, at what point does that special deposit get created in that situation?
Okay, when the
first
trust
of all, what is a res?
Put in the hands of the trustee, and that would be when you gave by a power of appointment to the bank the ability for them to appoint a title company being trustee, and then at closing, you went in there and you signed over the note and you gave it to the title company, who is the trustee. At that particular moment, at closing, you formed the trust because you handed Trust Res Property, the note, to the trustee, the title company.
So at the moment that the seller transfers the res to the trustee of the title company, at that moment a present transfer takes place.
Well, it wouldn't be the seller. It'd be the person making the purchase, supposedly, the buyer of the house, because you signed the note. But the signer on the note is the grantor. Once you signed the note, you gave the note to the trustee, the title company, and once they laid their hands on it, they received trust res, and that's when the trust was formed.
But that's with the bank. What about for the property taxes?
That's what the bank was, again?
I said that's with the bank, but what about with the property taxes? Where does the trust get formed there?
All right, property taxes, let's see.
I got an answer. This is Steve in California.
Oh, go ahead.
When your trust deed says that your house is in the county, Big C County, you're saying that it's in the corporation of the county already. It always is. And besides that, the insurance that's on it is adverse possession. But instead of your house being on the county small c, it's in the county, it's in a municipality, it's in the corporation, except their corporation's not even usually registered with the state of California. So it's totally foreign. You're living in your house, and you've given the house to a corporation, and it's considered public property for private use. That's why it's taxed.
So are you saying that from seller to buyer, for example, that it never leaves the trust of the county? It got granted there by the person who originally laid claim on the land, and the county just remains the beneficiary, and they just continue to assign successor trustees?
Yeah,
they originally applied for a building permit and wanted to build a structure. They've had possession of it ever since.
Yeah, look up the definition of privity of estate, which is really estate as trust. And in there it talks about successor or successive trust. And all you're doing in the county is just selling the property in a successive trust.
Because it's identified by the county notations, plot plan, so-and-so at such and such map and everything else.
That's called codified.
So let's go back to the original frame of our conversation, and that's special deposit. So the special deposit being res, right, Christian?
Right.
Okay. So the original person who laid claim to the land that went for the building permit, that's when he granted the res, and then it remained with in the trust held by the Big C County, and then they just continue to assign successor trustees, right? Which is us.
Well, no, you actually, because if you look at your warranty deed, it says that the grantor is really the previous seller, and you, the current buyer, is listed as a trustee. Now, they don't specify who the beneficiary is, but that's got to be the county, since you don't explain it any differently.
Because the trust says the house is in the county, and it's not in the corporation, and you can't even mortgage public property. You cannot mortgage the airport, the golf course, or the park, or the library.
So now when you, as the trustee, turn around and sell the property, you now become the grantor, and then the new buyer becomes the trustee, and what do? They record it back in the county again. So it really never leaves the county. So everybody...
So if you never recorded it, you would never it would never go back to them?
Back to who?
Back to the county. When you were buying the house and you didn't record that deed, it wouldn't go back to the county.
Yeah, but you still have a trust that's still in existence, and until you merge the titles or terminate the trust is still in existence.
But before we get that far, let's go back to the actual concept of the special deposit here. So the special deposit is the property, is it my signature, or is it that and more?
Well, it could be many things. It could be
the lien.
Yeah, it could be the mortgage, because it says on a trust deposit, a trust receipt is a UCC filing plus a security agreement.
Right title and interest is the lien.
Doesn't it say actually a trust deposit is a pre-UCC device or trust receipt?
Yes, it says pre-UCC, but it also says now governed by Article 9 of the Code.
So it really crosses over both?
Yes, it was a pre-UCC device, but it's also now governed by Article 9. It's a UCC device.
So what does it sit on the fence?
Yeah, it's kind of like a portal thing, because your security agreement and your UCC filing can either be a debtor contract for the next 30 years or simultaneously be a receipt of a payment. You pick the one you want. You never expressed it to be a trust, therefore it's not a trust receipt. You chose the debtor-creditor route, and you made it a 30-year obligation for debt.
Now you see why I'm trying to have this discussion about special deposit, because it really is, it's black and white.
Yeah, there's no middle ground.
I mean, but it's simultaneously black and white, and it's just about it's on what we're conscious and aware of to take what direction we need to.
Yeah, but there is a middle ground because you could state a claim that your mortgage was paid in advance with the promissory note.
Yeah, because now you're trying to make a correction and bring it back over onto the trust side.
But that would be with the mortgage company, right, Steve? Not in the property tax area, right?
Well, the property tax area, you would be better off to claim that they're taxing it in millage instead of millie, and millage has been unlawful since Nixon was president. Millie is $1 per $1,000 value, and millie is by the cent.
Right,
so
but my question was that what you're talking about is when you made your statement before you brought up about the millage and the millie was on the mortgage company side, not on the property tax side, correct?
Well,
right.
you have to know who's holding the collateral before you sign the mortgage, before you sign the promissory note, or before you entered the contract, who had the collateral.
Right. Well, okay.
The insurance company.
So if we're gonna bring the insurance company in on this, as Steve is suggesting, Christian, how can we grab the res from them and express?
Well, it comes back down to where we were talking about setting the law form, because that's going to determine, what rules they're thinking that it's going under. And I was trying to pull up here the thing we used in the cases. See if I can find that.
It's really a mess.
Well, they intentionally did this to spiderweb it, so they've got everything crisscross. So everyone's got a piece of the pie.
Yeah.
So it's going to be difficult to dissolve the trust, merge the title, because you do one, then you have to do it on the insurance side, then you got to do it on the county side. It's a difficult process all the way through. If you just want to get rid of the mortgage and still pay your taxes and all that stuff, then fine, you can do that. But it's a different process for each position that has claim to the property.
Right, until you understand the dynamics of what's going on and you call them on what they're doing, because if your promissory note has been converted into a draft and your mortgage is paid in advance, then it ends right there, and then it's not in commerce anymore. You could put it on small C county and own it outright, and they have no claim at all, because all you're doing is paying for the interest on what they're borrowing to operate fixed roads. They use you as surety, and they've mortgaged your sidewalk or your front area of your property, some little area that they think they have a claim on, and they mortgaged another, they've used your property as surety and mortgaged it so that they can go borrow money from New York.
Yeah, I understand that.
They didn't tell you that they were using your property as surety or a collateral to go borrow money.
Yeah, I understand that, but then you have to get into the realm of electricity, water, trash. I mean, there's all sorts of trust all over the place.
But those are all private contracts.
Yeah, those are like private obligations. Those aren't really trusts. I mean, they're trusts, but it's like.
Well, when I used to live in Southern California, the city, we had to pay the city because the city set up the trust because they wanted, to charge us and make money off of us at the same time paying a lesser amount to a corporation to pick up the trash. The city got their hands into everything.
Here's what will end the whole thing. Is really the grantor is the law setter of the whole case. Whatever he says, that's what goes. We're going to have to...
It's got a cell phone that's interfering with a computer or something.
Yeah, something here. I'm going to press mute, and everybody has to press star 5 to unmute.
Muted. Unmuted. All callers are muted and they can unmute themselves.
Okay, so what I was saying was that the grantor he's the one who sets the law form. We used that 3 basic lines in the cases we put in without waiving any right, remedy, or defenses, whereas I, then the grantor, am competent with intent and purpose as the grantor/settler, and then there's a footnote. So the footnote, I'll read a little bit later, but then the grantor/settler of the express revocable modifiable trust filed, now coming as the beneficiary in above named action in good faith states as follows, blah, 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 rest of the stuff. Now, but the footnote then, where unlawful or illegal purpose is really, in construing trust, unlawful purpose should not be imputed to the settler. And then I list the case sites to support that. The purpose for which trust may be created is, quote, the intent and purpose of the settler of the truth is the law of the trust, unquote. And then there's 3 case sites to support that. But the fact is that it's the intent and purpose of the settler, the grantor, that's what sets the law of the case. It ends all arguments. They have no right to tell the grantor what was in the law of the case, which was the indenture, which is really his intent and purpose. As long as for a lawful purpose. That ends all the arguments. You as grantor set the law of the case.
As long as we're on the private side.
Yes. So when I set my law form, say 1776, it was my intent and purpose, that's what it is. And all these other arguments about all this statutory stuff is cut out. So as long as the grantor is alive, he can come back in and he can reform and fix all these misconstruements because they weren't exactly particularly laid out in verbiage. But he can come back in. You're in there anyway of the case. And whatever you say as your intent and purpose, that's what goes. And they can't say otherwise. So you just remember, you're the one holding the big stick. And all these other arguments, they just fall moot. I just say, that was not my intent. That was a mistake. I'm setting the correction here. This is what I meant. It'd be the same thing as putting a little caveat on there and saying, well, all meanings are as the grantor understands them.
Or directs them to be?
Yes.
That could be another way to qualify our signatures too, right?
Yes, because you don't even need an ellipsis. You don't even sign by grantor. You don't even need to do that. If you just come back down to, it was my intent and purpose that this was a trust to begin with, and nobody can get me off of that except me myself. So if I say my intent, there's who else is to dispute it? How do you know what my intent was? I'm telling you, my intent was I'm signing by grantor.
Well, is this anything, Christian?
Yes, really. But under trust, protected with a CCI and brought in chambers to prove it, which comes.
Well, I mean, you're not just talking about mortgages right now.
No, anything, because everything really is a trust at this point.
Yeah. Well, I have a question about if the IRS says that you owe $95,000 in taxes for the last 20 years, which is what they're going to try and do now, and they come at you, and I know you were talking about we are the beneficiary. Well, we are the trustee because of the W-4 form, but if we know how to operate the trust, then we can operate it as trustee to their satisfaction. But I'm not sure I know how to do that. But let
me say that it proved to me that my special deposit did not pay all the debt that you're claiming.
Okay, my special deposit would have been the return of the form that they sent me?
Yes, whatever the offer was for the debt, to form a debtor-creditor relationship, because you never expressed it to be a trust. Now, express it to be a trust, claim that it is a trust, prove that it is a trust, and now show me otherwise that special deposit I made didn't make the payment.
Okay, so I can sign that as grantor anyway, right? Would that be the best way? Would that be the best way to sign it? Would be grantor?
Yes, that way it's plain to see that you're in a trust in that situation. There's no question of maybe being more secretive because I want to get my electric turned on, say. Under this,
yeah, well, I'm talking about income tax.
Signed by grantor, yeah, or signed by trustee if you're making a payment. I mean.
Well, a friend of mine has a situation, and
well, we're kind of getting off point. We're talking about trust res,
yeah.
So let's keep it to trust res for right now. Trust res is payment.
Trust res could be the bill that they sent me.
Yes. Mm-hmm.
Okay, so let's use that as an example of trust res for a minute.
What is really the bill?
The bill is so many dollars that you owe the IRS in back taxes.
Okay, under debtor creditor. All right. So that's the debt title.
Right.
So now, what is the counter of that, which is the title to the assets? What represents the title to the asset?
The amount of money that they're saying that you owe.
No, that's the title to the debt.
Hmm.
What is the title to the asset, which is the trust res?
Oh, I thought that's what the trust res was.
The signature. Your signature.
Yeah, well, okay.
When you boil it all down to your signature is trust res.
Oh, okay. All right. So if you sign it grantor, then that would take care of it.
Yes.
All right. But you'd have to put it on your
records that you're forming it, that you're doing it under trust.
Yeah, but you would have to put that on your UC1 and then transfer it on your 3.
Yes, if you haven't already claimed trust, yes. But if you've already claimed trust and now you're trying to make a payment, then you're going to have to do another 1 and a 3.
Okay. Okay. Let's say that they come to me and they say, well, let's see now. 10 years ago, you owed $30,000 and you didn't pay it.
Okay. Let's get out of the debtor creditor mode and call that what now?
Let's call that trust.
No, let's call that a debt title.
Oh, a debt title. Okay.
Let's call that chattel. That's chattel, whether it be real or personal, because trust is talking about chattel.
Okay, so they send me this chattel, and they say that I owe $30,000 of chattel.
Yeah, it's a debt chattel title, say. Debt title.
So then I just...
It's the offer for the free obligation. The offer is free, but the obligation is not. The obligation is you got to pay. But anyway, it represents a debt title, a chattel.
So when I sign that grantor and I send that back to him with my signature on it, then that's the payment.
Yeah. What did you really do? What's the payment?
I just gave them a special deposit.
Correct. But now we had a debt title. What do we got now?
We have a negotiable instrument now, don't we?
We better not, because if you got a negotiable instrument, you don't have trust.
All right. What would it be under trust?
You better have a non-negotiable instrument.
Oh, no. Okay.
Non-negotiable is private. What did I read about a certificate of deposit not more than 10 minutes ago?
Okay.
It says these certificates may be either negotiable, which are public, or non-negotiable, which are private. Which one do you want?
Oh, non-negotiable.
Non-negotiable, because that's private.
Right.
Where does trust operate? In the private.
Private.
Yes. All special deposits are non-negotiable. Non-negotiable CDs.
Okay.
If you make
right,
negotiable, you just commingle the trust, and you ain't got a trust. You're in breach of trust.
Right. Okay. So now that I've returned them a non-negotiable instrument.
Well, let's start talking about trust. We got a debt title, which is chattel. What did we really give them when we returned it as a special deposit, which was non-negotiable?
A non-negotiable instrument, right?
No, I'm trying to get you to pull out something else, another label. Anybody else? Anybody else want to jump in?
Ask the question again.
If we have a debt title and we made a special deposit after we signed it and returned it to them, and we made a special deposit, non-negotiable, what did we just do? What did we create?
Trust.
Yeah, but what we created was an asset
Transfer
title.
Oh, an asset title. Okay.
So the debt title represented the public side. The asset title represented the trust or the private side. Now you got two sides, two titles that you can merge.
Okay.
We got to get out of this debtor-creditor thinking, because that's what's holding us up.
Yeah.
So let's take those two sides, the debt title and the asset title.
Uh-huh.
All right, and let's use them to port through or look through the frame of banking relationships, property tax relationships,
anything,
court case relationships.
Yes.
All of them operate on both of those sides, correct?
Correct. Mm-hmm.
Okay. So he was just talking about a mortgage situation, correct?
Mm-hmm. Or an IRS issue.
Oh, an IRS. I'm sorry. Let's take it in a court case situation and look at the asset title and the debt title and actually determine which pieces of that play the debt title and the asset title role. When, for example, we have a case number, which is our res, and what becomes the asset title and the debt title?
Well, when they gave you the offer for the invitation to come into court and form a debtor-creditor relationship, that was the debt title again. Then when you signed your name as grantor, you turned it into an asset title, and when you give it back to them, you made a special deposit under trust. Except you never created the trust receipt. And what's the trust receipt?
I got the definition right here. You want me to share it?
Yeah, go ahead.
Yeah.
This is out of Black's Fourth. Document in which is expressed security transaction where under the lender having no prior title in the goods on which the lien is to be given and not having possession which remains in the borrower lends his money to the borrower on security of the goods, which the borrower is privileged to sell clear of the lien on agreement to pay all or part of the proceeds of the sale to the lender. And I know that there's been a revised definition, but the reason I brought that up is because this Black's is more geared towards trust, isn't it, Christian?
Yeah, I was looking up the other one also, the one I use all the time.
Right, but isn't that the fact that the older Blacks are more geared towards trust and the newer ones are more geared towards debtor-creditor?
Yeah, they can be. They can.
Okay. So where we really fall on a lot of this is we fail to issue trust receipts.
Yes, we fall right in the debtor-creditor trap, and we start operating as fictions under the debtor. You start acting. You're an actor on all this. You're an actor creating the records for them that hangs you.
So I guess one of the major things we really need to work on is learning how and when to create trust receipts.
Knowing and understanding which is sentier, because when you know and understand, you are no longer a fiction. You're operating as a real man with knowledge and understanding, and you're now competent. Competent to handle your own affairs.
So one of the elements of being sentient and competent is to issue trust receipts.
Yes.
Okay.
Well, okay.
Now here's trust receipt. Trust receipt out of Black's 8. It says a pre-UCC security device, now governed by Article 9 of the Code, consisting of a receipt stating that the wholesale buyer has possession of the goods for the benefit of the financier. And today, there must usually be a security agreement, now that would be trust res, coupled with a filed financing statement, a UCC 1 or 3. The security agreement is the indenture, the indenture.
Could we call a receipt a title?
Yes, it's title to the payment.
So
it's the merging of the titles that is the receipt that you merged and terminated the trust.
Right. The legal title and the beneficial title, when those two are merged, then the trust satisfies.
Yes, the trust terminates, and now the trustee must disperse the funds to the beneficiary. So instead of dispersing the funds to you, just apply the funds to the debt, wipe it out. And if there's any proceeds left over, send me that. Yes.
How would you behave on a closing at escrow?
Well, put your 45 on the table first, and then go ahead and sign it.
Okay. Well, you're supposed to claim a receipt for the trust, so how would you behave?
At a closing?
Yes. Let's pretend you're buying a home. They call you in to sign documents.
All right. To make it run smoothly, I put ... and my signature.
Where's your receipt?
Well, when you take the security agreement and file it on a financing statement.
Because should we file a UC1 before they do, so that we can?
No, how can you? The trust hasn't formed yet.
I'm sorry?
No, how can you? The trust is not formed yet.
Okay. Yeah, but okay, I got you.
How could it be transferring trust property because that's what forms the trust, and that is a trust receipt, a special deposit.
Yeah, you're just
about really hasn't been done yet. You'd have to wait till after it was done.
Okay, so you have to wait until everything?
Yeah, you have to sign it and transfer the property. Once you transfer the property, immediately upon leaving there, you could go out and file a security and a financing statement then. Which
you can do everything before 72 hours, right?
No, that's debtor creditor. That's
I mean, it doesn't matter whether you do it in the trust. Time doesn't name debtor or creditor.
No, down to when was actual trust res put in the hands of the trustee.
Just 100 years later, if need be, right, Christian?
Yeah, just create a record when it was done, even though it was done, say, 100 years ago.
Or next day.
Yeah, right. I would wait. I would wait a day. That way, I got a signing on one date, and then the next day, I got another that I recorded all the stuff, and that was my receipt. But we're not creating any evidence under trust. We have absolutely no record of any trust of anything, and we've signed all these documents under debtor creditor, and they got tons of these debtor creditor documents, but you never signed anything under trust. You never expressed a trust. Got no evidence to support a trust. That's where we're all falling down.
So going back to doing the UCC 1 and a 3, that is the trust receipt.
Right. 1 and a 3.
Okay.
The 3 represents the transfer. That is the trust receipt.
So that's why you've been talking about it ever since the beginning, really.
I know. Finally.
Well, it takes us a little time to connect all the dots, and every phone call another dot gets connected. So all this stuff. We try our best.
Hallelujah.
Right. So that is so is that the end of the cycle? Is the trust receipt?
Well,
that's
your receipt of a payment.
Well, now isn't the UCC 1 also the NOI or the SOI?
Yeah, but that just claims it, so I know that it's mine, and I can do something with it. Transfer it on 3.
That's the record of it, sir.
But then is that the record of the SOI?
Yeah, that's the SOI. Yes, the one is also.
That is the SOI.
Yeah, an SOI and an NOI can be simultaneously the same thing if it states a claim, and then it's also a material fact. So if I went into court and I said the guy broke my arm, that's a claim. But now here's my X-rays, professional affidavits, the bills. Here's what it cost me to fix my arm, the X-rays, and all that evidence and stuff, all attached together, all at one thing. It was simultaneously an NOI and an SOI. It's just like a 12b-6. You fail to state a claim upon relief can be granted. Well, you didn't have an SOI supporting your NOI. Silence.
Okay.
We're learning how stupid we really are.
Well, we're not stupid. We're just uneducated.
Same thing.
Christian, I have a question. How would you close a case on the private side?
Okay, you skipped out there. I didn't hear you.
How would you close out a court case on the private side?
You probably already have. You did an administrative remedy. But you got to close it out on a public side, too. You got to be in control of both sides. You have to get that.
When you say I probably have when I did an administrative remedy?
Yes, because if you did I'm assuming you did an administrative remedy, closing out a bill, did a process, that would close out the private side. Your second step under, say, except for value would be to now get a public recognition of a public closure of recognition of that private settlement on the private side.
Are you saying that the private side would just be the accepting for value?
Yeah, under debtor creditor, yeah. But now you got another problem. You got a trust that's sitting over top of it under discretion whether or not you get a recognition or not per discretion of the trustee. So now you're limited to 10% success.
That's under debtor creditor, though.
Yes, under debtor creditor. Okay. That's my point. Yeah.
Yeah.
So if you handle that as a trust right from the beginning, then you won't have to turn about that 10% crap.
Yeah, it flips. Now my private side is really my title to the asset instead of it being on the public side being the title to the debt. And now we're talking titles, right? Title and interest, which is really trust.
So if there's a court case there was a summary judgment for a debt collection thing, and it's been sitting there since 2007.
Mm-hmm. Which is a debt title.
How would one go about clearing that up, having that go away?
Okay, everything you said there was in that case. That's a debt title. Now, turn that debt title into an asset title. Look at it like, okay, what they gave you was simultaneously a debt title and an asset title when you give it back to them as special deposit. It represents both titles. Now all you got to do is just create the records that you sent it to the one entity, and you merge both titles. Treat it as a trust deposit, which was really a trust receipt, which was a payment.
I'm just learning about trust, so I can't quite see what this would look like exactly yet.
All right, picture somebody giving you an offer, handing it to you. That was an offer for a debtor-creditor relationship for the next 30 years, or go to jail, say, for a court case, or a foreclosure, and when you accepted it, what you did with it next determines whether or not it's a debtor-creditor relationship or a trust deposit.
I didn't know anything then, and they got a summary judgment against the defendant.
Well, you probably have to go back in and open up the case again with another, depending on how long ago it was. And then it comes back in with evidence that it was trusts, and a trust receipt was generated from the trust deposit and really was paid. Motion to set aside because one of the grounds would be it was paid.
They're just trying to double dip.
Yeah. Plus all the bonds in the background, yeah. The proceeds therefrom. But it all stems from signature. Your signature is the trust res. So I'm giving you my signature as the asset, the trust res, under a special deposit. But the piece that my signature is on, that is, under trust, a title to the asset. That's an asset title.
But that's non-negotiable.
Non-negotiable, yeah.
Okay, always.
Yes, it's got to be non-negotiable if it's on the private side. So how can debtor-creditor be accessing anything private when they're all negotiable instruments? Can't. We've been operating under the debt side thinking it was all private. It's not. Can't be. All these...
Okay, we just didn't know how to find private and public.
Right.
In commerce, that's all.
Right. Commerce is all debtor. It's all, it's all public.
Right.
If I'm doing trust, I'm not doing commerce. I'm doing something totally different. It's not commerce.
Okay, but in order to bridge the gap that we're trying to figure out here, when we transfer from commerce to private or trust, we have to equate something. And that's what I have to equate. I have to equate commerce and trust. And okay, so commerce is public, trust is private.
Correct.
Yeah, got it.
Now, when we generate interest off of the special deposit, what is the source of the interest? The special deposit. What is the source of the special deposit? My private signature. So what is the source of the interest? Private. Is it effectively connected with a business or trade in the United States? No, not under trust. Not if it's non-negotiable.
So how do I get them to cooperate with me on that?
Well, see, they're the brokers on the interest transaction on a tranche, and they can generate that because they're the ones that are necessary for it. Because if you do it, you're going to be effectively connecting yourself with a business or trade again.
Okay, so how do you do that then? I got this guy out here that he wants to make money off of my signature. So what do I get him to do that?
There is no money. We're talking about trust. Okay. It's talking about a res thing. My right, title, and interest, and I want to generate some interest in this.
Okay.
Please let Christian finish before you interrupt him, because you can't hear what anybody's saying.
On the W8Ben instructions on page 7, well, actually on the form itself in block 3 is where it lists your foreign simple trust. And we've been talking about simple trusts in this Monday night call for the trust ambassadors, and we've been talking about the special trust or simple trust in the practical treatise on trust law by Lewin. But on the Ben form on page 7, it's talking about broker transactions or barter exchanges. And it talks about you are neither engaged in a U.S. trade or business or connected gains or transactions with a broker or barter exchange. And then it talks about on the publication 515, IRS publication, on page 4, it talks about the non-resident aliens that are subject to withholding. And
what page are you on, 515?
That was page 4, I believe. And then we want to jump to page 14, which is talking about income subject to NRA withholding, and particularly where it says amounts not subject to NRA withholding. The following amounts are not subject to NRA withholding, and on the second bullet it says bank deposit interest. That is not effectively connected with the conduct of a U.S. trade or business. See interest later. That's on page 18 there. And then down below that it talks about the next heading is the source of income, and really it's talking about the source of income or payment or interest again. And it says generally interest on an obligation for a foreign corporation or foreign partner is foreign source income if the entity is engaged in a trade or business in the United States during its tax year. Interest paid by such an entity is treated as from U.S. source only if the interest is paid by a U.S. trade or business conducted by the entity or is allocable to the income that is treated as effectively connected with a conduct of a U.S. trade or business. So then we go to page 16. It talks about under the effectively connected income section, under income from securities, it says in the next paragraph, says, if the foreign person's U.S. office actively and materially participates. So if you actively or materially participate in soliciting, negotiating, or performing other activities required to arrange the acquisition of the securities, the U.S. source of interest or dividend income from the security is attributable to the U.S. office and is effectively connected income. So you need a broker. Got to have a broker. Then you go to page 18 on the section talking about interest on deposits. It says income code 29. Foreign persons are not subject to withholding on interest. That is not connected with a U.S. trade or business if it is from, first bullet, deposits with persons carrying on banking business. And I could go to the Banker's Handbook again under the section number 1902, section, number 3, talks about opening up an account. It says that you're making the deposit, you're the banker. Second bullet on this publication, 515, deposits, and it's or similar associations. Well, there's your broker transactions and barter exchanges off your page 7 off of the W-Ben instructions. And now the first paragraph after the 3 bullets, it says deposits include certificates of deposits, open account time deposits, and other deposit arrangements. Now, what would your other deposit arrangements be? Trust deposits, special deposits, which have contracts or agreements, let's put it that way, for interest that are non-negotiable transactions under the barter exchange, which is not effectively connected with a business or trade because the interest generated is really generated off of my signature, and my signature is from the real man, and where's the real man in the private, who is a non-resident alien not effectively connected with the United States business or trade, all generated off of my signature, which was trust res, which is what I put on their offer for debtor-creditor, turning it in from a offer of debtor-creditor, turned it into a debt title, but simultaneously, when I put my signature on it, turned it into an asset title, what I returned back to them under special deposit, which represented the counterbalance, and we merged 2 titles.
By creating the trust receipt.
A trust receipt, a record of a payment. But I never put a CD with it to generate the interest.
So suggest to us what that CD might look like.
Well, I think I gave somebody a CD that we put together before. Was it JC or I think it was JC. Maybe you have it, Eric. I don't know.
I don't, but I mean, just I mean, is it just a letter we type up, for example?
No, what I did when we were doing all this debtor-creditor stuff was I took the actual notary certificate that everybody was using, that certificate of dishonor, and I changed it around, and I titled it Certificate of Deposit. So now when the notary makes a deposit or presentment to, say, the Treasury at that time, I generated a certificate of deposit. I had the notary generate that and certify that under his hand and seal that he made a deposit. He certified a deposit being put into the mail, a depository, and he mailed it to the Treasury. And I generated a certificate of deposit, a CD.
But you read earlier that you need a broker to do this.
Well, my notary was my broker. I didn't know that.
So in other words, you're as long as you're using somebody else besides yourself, then that's your broker.
Yeah, because you can't do it because you would effectively connect yourself to it.
Yeah, that would be commingling funds if you did it.
Right. But back to Trust Res. Trust Res is nothing more than my signature, whatever I put my signature on, which is the counterbalance to whatever it was the offer. And it doesn't make any difference what the amount was because we're not talking about amounts under debt or credit. We're talking about thing or res under trust. We're talking about a chattel, whether it be real or personal. So whatever offer that they give me that comes in the mail under debt or creditor being, say, 3-115 is an incomplete instrument, look at the signature. I'm going to treat it as Trust Res, my signature Trust Res, and refer to them as the counterbalance title to pay, or the asset title to, or merge the two titles. And under Section 159 of the Gilberts, when you merge titles, that's acting as a bill of exchange, really. So we're exchanging two bills there, two titles, exchanging the debt title for the asset title, and when you combine the plus with the minus, you get zero.
Christian?
Yeah, Pete, go ahead.
Right. How would you set the rate of interest?
How much interest do you want?
100%, obviously.
Weekly.
Well, I think the question that he's really asking is what specifically, not the amount, but how would we set it?
Yeah.
On the CD.
On the certificate of deposit?
Yes.
Which is done by the notary, which is a non-negotiable instrument.
Right, and it's per the intent and purpose of the grantor.
So we come in with a claim, which is
we never contracted for any interest.
Sorry?
We never colorably contracted for any interest. Under this would be a contract, say, under trust, though, or it would be a private agreement to generate interest.
So would the interest be generated from the profit that is taken from
no, there
special
is
deposit only?
Debtor creditor.
The res.
Yeah, it's the interest generated off the res, which is what? My signature.
That the trustee accepted.
Correct.
So they account for that as an asset on their books?
Yeah, he should be ledgering it as a special deposit and not commingling it because it is supposed to be returned. It is hereby directed to be returned to me, my records, in their original form sometime in the future with interest.
So going back to
because it is my interest.
So going back to what you suggested a minute ago, for example, 100% a week, by claiming a special deposit and transferring it to them at 100% a week because the trustee has the responsibility to properly manage the res.
Yes, let the Treasury generate the tranches and the interest.
Well, let's use that, for example, in a ticket of a speeding case of a speeding ticket, and you generate 100% a day, for example. You're going to make that a hot potato. They're going to want to get back to you right away, aren't you?
Yes, put it in the new LLC that I formed on the public side, deposit it into that account so I can write checks on it. And it's nowhere wiser to anybody else because it's all credit, it's all same thing. It's all can be turned into Federal Reserve notes.
But my point,
what is its source?
My signature.
Your signature, which is private. And now, is it effectively connected with a business or trade? No. Did I have any?
Are you talking about after you corrected the IMF?
Well, yeah, we could do this maybe before the IMF. I don't know. But it'd probably be better if we did it after, yeah, or simultaneously at the same time.
But by, for example, doing a 100% a day rate of return based on my signature, and they're holding on to it, they're going to want to get that away from them and disperse that as fast as possible, so they don't have to continue to generate that 100%.
Well, it could be for a 40-week trade.
But if they mismanage it and hang on to it for a longer period beyond that, that's their issue. That's on them, right?
Yeah, but it's per your instructions as grantor.
Okay.
You're never expressing it to be a trust. You're the one setting the law in this whole case.
Right. So, but as soon as I do express it as a trust, if they decided to hang on to the res because they thought they were going to be smarter than me, or they said, you know, our stick is bigger than yours, I'd say, okay, feel free, hang on to it.
Yeah. Well, you never expressed it to be a trust because you didn't know or understand it was a trust. So
once I did,
how could you set the rule of the case?
Okay.
I thought you expressed it as a trust when you signed it as grantor.
Yeah, you started to. That's the starting point. But
you still got to prove it through record.
Yeah, you still have to prove the trust.
Okay, so then that's when you do your UCC1 and UC3s, right?
Right. That's the records that prove that you got a trust on your claim that you got a trust.
Okay. So then, if you have to go into court, you have your record.
You do and they don't.
Yeah, they got the records under debtor creditor, and we got no records under trust.
Well, I thought we filed it. Into the.
That's what I'm pointing. Start creating records under trust, and then start proving you got a trust with it. Because they're proving you got a debtor-creditor relationship with them with all the documents that you signed as debtor-creditor. And you're not breaking any of those presumptions with any counter records to prove otherwise.
Well, I thought that if you signed it as grantor, that's not debtor-creditor.
But if you only sign it as grantor and you don't file in the public to create your two witnesses, their body of evidence outweighs yours.
No, that's what I'm saying. That you do file it into the county.
Yes, the notices, all right.
Then at that point, your body of evidence outweighs theirs.
At the dib hearing in chambers.
Sounds like the silver bullet.
Well, you're operating what they've been operating. That's what Christian has been telling us. That's what they've been doing to us all this time. So
since 33.
Take notice and acknowledgement with agreement that this show and or documents is private and not to be construed or relied upon as being legal advice for an individual legal situation or implored for making a legal decision. You will not use any of this information for making a legal decision or performing a legal procedure and is not a substitute for legal advice and or guidance by a licensed attorney. This private show and or documents are for academic informational purposes only to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show or using the documents therein, you understand with agreement that, with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of herein referenced, and has no interest in any use referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity as liaisons to communications between the parties. By reading and or using this information, you acknowledge and agree that you are not a client of Christian Walters. These documents and or show recordings are incomplete and void without this notice agreement being attached herein by reference, and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding.
Now, Christian, this is Bill from New Jersey. How are you?
Okay, good. How are you?
Good, thanks. Good. Just to clarify something about the certificate of deposit, I'm understanding we can get certificate of deposit any bill and forward directions to the trustee to keep it segregated and then as a private, non-negotiable instrument, and have them generate interest as we see fit. Is that correct?
I might want to be the trustee, because the trustee is the one that's got the right to make the payment. So if you wanted to have somebody else the trustee, you're going to have that in the indenture, because that's going to be the instructions or the will of the grantor that tells that trustee what he's got to do. So you could do it either way, you know.
Well, what I'm suggesting is that when we have all these, we get our bills in the mail, you know, whoever sends us the bill, if we send it back to that entity with instructions segregated, and by our filing UCC, we make it a certificate of deposit.
Yeah, there's two ways of looking at that. They're looking at it, they're construing it to be for us to be the trustee, which, you know, the documents that we've signed and the 1040 forms, and that we set ourselves up as trustees. So they're sending the documents, or the receipts, the bills and stuff to the trustee. So they give it to us. But what we do with that, do we make a payment in return as a trust asset, asset title? And do we express it as a trust? Or do we turn around and handle it as debtor-creditor?
Well, that's what I was suggesting. We're talking trust. So on the trust side, speaking trust side, we're going to convert that into an asset by making it a special deposit.
Yeah. Now, if I'm trustee, I can turn it into the asset and send it back to as a payment. But now, if I appoint him trustee, now I got to give him instructions, and he's got to do the payment.
Right. That's what I was suggesting. In other words, we send it right back. It's a hot potato. We take the hot potato, we qualify with instructions and send it back to the sender, and now that person has responsibility. Failure to meet the instructions, they're in default.
Yes.
Breaching the trust.
Mm-hmm.
So it seems to me that whatever bill we receive in the mail, now, as you said earlier, under terms of value, it's the same process. Now we just took it back to them, give them the limited authority to handle that with her instructions, and the case is settled or closed.
If he makes a payment.
Okay. If he makes a payment. Oh, that's why you keep. Okay, suppose he doesn't. Okay, actually, that's why I would want to be trustee, because I would make the
Yes, and once I've made the payment as me being trustee, now I don't care what that guy does. I've sent him payment. Now I'm going to take my records and documentation that I made a payment, send it to the IRS, and they're going to make sure that his records are going to comport with my records. Because I'm going to do a hearing 25-06 and tell them to adjust the records so that accounts reflect that I've made a payment.
Okay. Now, maybe I missed that, but what do we do to make the payment?
Make a special deposit.
And with whom? With the Treasury? Is that right?
No. Who gave you the offer?
Excuse me?
Who gave you the offer?
Okay, so we give it. So that's what I'm trying to say. We flip it back to the guy who gave the offer. That's our payment.
Yes, we give it back to them. That whoever gave us the offer, we give it back to them as a trust receipt, which is a payment.
Exactly.
Create the records that you made that payment. Send all that stuff up to the IRS and call it DIB hearing.
Oh, I got you. Okay, I got it.
IRS and Treasurer are synonymous.
So we would send it to the agent of the Treasury, the IRS.
Yeah, call it Treasury Directive Hearing. Tell them to correct the records because it does match up. I put the correction records in the IMF, IRS, U.S. Treasury, call the hearing, and now this ABC offerer that sent me the offer has to correct their records because it's got to match up with the individual master file correction that I made.
Now, should they fail to comply with that, what happens?
CID.
Yeah, CID and breach of trust.
Okay. Now, in our correspondence with them, do we allude to the CID, or do we just let them figure it out themselves?
Yeah, you could bring in the CID. But before I did all that, I'm going to have to make sure I request my special deposit back to get them in a breach. I don't want to say request. I want to order the surrender of my special deposit.
Now, I wasn't clear on how the notary fits in with the certificate of deposit. Can you clarify that again, please?
He's more or less my broker on the instructions there to generate the interest. And he's also creating a record of the presentment and certifying the documents that a presentment was made, which I'm going to incorporate that in with my UCC 1s and 3s because he made the presentments, and it's going to be under his hand and seal as my third-party witness with clean hands at arm's length.
So then the notary is just notarizing the fact that there's a document that requests interest payments on this particular rents.
It can. A CD doesn't have to require interest. It's just whether or not you put it in there or not.
Right. I'm saying it's a non-negotiable instrument that we're supposed to the offeror, and whether it's negotiable, whether it's interest-bearing or not.
And what's the interest going to be worth?
Excuse me?
And what's the interest going to be worth?
Whatever we determine.
Well, it's mine because it's generated off my signature. That's my interest.
Well, then why was the conversation before about the 100% today? I mean, any percent we want. Isn't that right?
That's on the debtor-creditor side, but I'm talking about trust now, and now it's my interest. Oh. It's based off my signature.
And that's just because the interest on that is what?
My point is we have to start thinking in a foreign language simultaneously. We have to think on both sides. We have to think debtor-creditor, and we have to think trust, because interest is expressed or defined differently on either side. Interest on debtor-creditor is, say, $500 million, but interest on trust side is, it's mine. It's based off my signature. That's public and private.
That's right. That's where we have to keep public and private separate.
Yes. We have to think two-dimensionally. We have to start thinking in English and a foreign language.
In regards to the notary, what if the notary wants to also do the same process? He can't be a notary because he's doing business, or do the process because he's doing business with the U.S., is that correct?
Yeah, I couldn't do that. That's why we would do is say the notary.
I think one thing that might help Bill from New Jersey understand this a little better is that interest is a portal word.
Just about every one of the words are portal words because we've been brainwashed to think under debtor-creditor, but these things have different meanings under trust.
I asked you before, Christian, about the word interest. For example, does it mean 7% on $100, or does it mean that I have a stake in the game? And you said it means both.
Yes.
So I hope that helps Bill understand that a little bit better.
Depends on what side you're coming from, because it's relative from your point of view.
Yeah. Thanks for the input. I got that pretty much. Thank you. I got that. I thought we were on the trust side, but I get the other side. Yeah. It doesn't really matter. The question is, we're going to forward this to by means of notary to the offeror with our instructions and certificate of deposit, and that's our proof. And we put that with our papers in CC1.
Correct. Right.
Right. Okay.
That certificate is actually another record, more weight of evidence for me to support a trust.
Right. Definitely.
And that CD, would we hold that in the private?
Yes.
And that would only be introduced in a DIB hearing.
Uh-huh.
Okay.
Well, we private because it's non-negotiable.
Right, and it's non-negotiable written right on it. And then don't try to recontract over the top of that with trying to negotiate it.
How, by what authority is that?
By you putting it in the public?
Oh, right, but it's in the private, non-negotiable, and that's who we are.
Yeah, well, make sure you put a protective order on so it doesn't show up in the public anywhere, because as soon as it does, you got to object to it, or else you're going to waive it, and they're going to treat it as negotiable.
Oh, I see. Okay, so in addition to filing it on the UC1, do we have to put...
No, we don't file it on a UC1. We just make reference to it under the RA number, which is all the documents held in private, and that is included with it.
Right, I misspoke. I didn't mean to file. I mean to give notice. Right, I'm clear on that. I misspoke. But then with that, we have to add on protective order. Is that what you're saying?
Yes, if you're going to have any... if there's anybody trying to bring it into the public, yeah, you're going to have to object, and you're going to have to put a protective order on it.
So the protective order is to prevent bringing it into the public. Is that what you're saying?
Yes, right.
So do you issue the protective order at the same time that you issue the...
I don't have to, no, because I'm not trying to bring it into the public. If somebody else tries to bring it into the public, say, I have to immediately object and put a protective order on it.
Christian, that generates an interesting scenario. The only way that it would ever get brought forward is by us, and that would be in a DIB hearing, correct?
Yes, or maybe the other person that you did the private agreement with on the other side, your agreement, might be trying to bring it into the public. Well, then I have to object and immediately put a protective order on it.
And that would apply to all private administrative process, correct?
Yeah, right.
Okay.
We've been failing.
Well, in that scenario, that'll only occur when we had to go to court because...
Yes, they're trying to make it public in court.
Right, but prior to
I have to object to that because I got CCI information that can't be heard in court.
Exactly. Prior to that time, though, they wouldn't know what it was because we didn't tell. We just had it on the UCC1 under the AR number.
Yeah, well, they may know what it is, and now they're trying to bring it in and make it public so that it's waived.
Okay. Oh, I see. You're saying even if I bring it in or someone else brings it in, then it's a...
Yeah, you got to object.
Okay, I got you.
Object and hit them with a protective order.
Right. That makes more sense now with respect to the confidential information because state secrets, that's what you're really saying because I wasn't aware that the other party or any third party could take my information and make it public. Because I thought that was on the UCC1. It was my private property.
No, that's a public notice, that UCC filing.
Yeah, probably not. Once again, I misspoke. Public notice. Right?
Yeah.
Well, the thing is, if you're forming the trust, you have to notify the other party, which is the trustee, and he's going to try and divulge that information in the public side, and that's why you have to do the protective order. Is that correct, CW?
Yeah, he may try to do that.
Yeah, on the other hand, though, they don't have to know you're forming the trust.
Not to form the trust or to administer the trust, but if he's going to be trustee and administer the trust, if it's some other entity, he probably wouldn't have to know. But if we're trying to enforce a trust on a breach, then yeah.
Well, you've already noticed them that in your UC1 that the information is being held in private.
Yes.
Well, that would be a witness to what your intentions are.
Yeah, but let's go by the scenario. If I gave you my pen, I know I'm grantor, say, and I know you're trustee because I gave you my pen, but you don't know you're trustee. But then I go around and I file these UCC 1s and 3s, and I form the records that we did a trust.
Okay.
You still don't know that you're the trustee. Now, unless I put some kind of wording in there that tipped you off, but the only thing I gave you was an oral trust, I want my pen back. Now, when you don't give me my $3,000 Cartier pen back, now I'm going to bring the evidence for it, prove that there's a trust after I claimed that it was a trust, and then I'm going to get you in breach of trust because you didn't give me my pen back when I ordered my pen back, which was my specific res.
Right. I understand that. But what I'm saying is that now you put in your UCC1 that the information that you have or whatever put in as trust res is held in private. Now you have a witness in your UCC1 that you have told me to get your pen back or that your pen is in trust.
Yeah, but that wouldn't be on the notice. That would be on the privately held documents, right?
Yeah. Right. Exactly.
Because the only thing that would be on the notice would be just that I've transferred trust res of the such and such a number, RA number, such and such US.
Christian.
Yes.
Question is, what if you are making, on the UCC1, you're making a private notice of or a public notice of a private declaratory judgment via UCC1 against multiple parties for, let's
Where
say,
was the declaratory judgment gotten from? Or was it?
The administrative process was exhausted.
Okay, that doesn't tell me who generated it. Who had the authority to generate a declaratory judgment? Where did it come from?
From the party that's alleging they're damaged.
Okay, so the party saying that you broke my arm, they're the ones that they're determining, they're the judge and jury and everything all wrapped up in one. Is that right? Is that the way our law form works?
No.
No, okay. So it has to be an independent judge that's not biased.
Right. Now, also just getting back onto the UCC1 is where, of course, where typically you have, where it's listed, of course, on the forms itself, debtor, and then also secured party, which you change that under box 7 that says optional filer reference data. Now, number 1 is that's basically the straw man, but do you list that as trust or trustee? And then this way, once it's filed, then you can move the titles via UCC3.
Darren, I have examples of that for you, Darren.
Oh, okay. I'll get in touch with you then.
This is Eric.
Yeah.
And Christian, a moment ago when you said by a private party or by an independent party, you were referring to the notary, correct, Christian?
I was thinking that's who he should have said. It would have been the one that issued the declaratory judgment. Yeah.
So would it be the notary that files the UCC1? Up on top, where it says
that would be
name and
the only thing on the notice would be an RA number referencing, what the notary did that I'm holding in private. And that's.
But what I'm saying on the UCC1, like on the upper left-hand corner, it says, send acknowledgement to. Should it be the notary that's filing the judgment?
No, I don't want to bring him in. I'll keep him out of it. Keep it private.
But I thought the notary presentment is private.
Yeah, but I would want to listen and have send it to him, make it more known that's, more people that got involved with this, the more information they got to make it more public. Okay.
Darren, what he's saying is keep the notary private, but you could still go ahead and make a public notice filing of what's being held in the private. Does that answer your question?
Yeah, but you can technically declare a private declaratory judgment. You're saying, hey, I'm giving you notice. Here's what I believe I've been injured and damaged by.
Not in that notice. You do better not.
Why not?
Because that's making it
like you'll waive your CCI. You'll waive your substantive rights, Darren.
Okay.
Darren, you're breaking up. Try and keep the microphone away from your mouth.
Okay. No, it's planted. It might just be the reception. Okay. Very, very good.
Keep the notices with as little details as possible. Just make it referenced by like one number, an RA number, that points to all the documentation that I'm holding in private, all the details on it. And there's nothing referenced on this notice other than an RA number, than the fact that I've either claimed it or I've transferred it.
And Christian, it goes right back to the reason why we have to do that is it goes back to the definition of legal fiction, right?
Yeah, and Sentier and the fact that if I bring it in the public, I'm waiving it. I'm voluntarily disclosing it. I don't want to voluntarily disclose it. The definition I read last night, let me find it quick. It said that, as soon as you bring it in and you don't object to it, or if somebody else brings it in and you don't object to it, you voluntarily disclose it because you have no, it talked about, you had the opportunity and you took an, let me see if I can find a wording on it here. Failure to object to the introduction of otherwise privileged matter constitutes waiver. When the substance of the privileged information is revealed without objection. A personal, let's go to another one. So when a party himself creates or ceases to treat a matter as confidential, it loses its confidential character. When he waives the privilege, is when he voluntarily discloses or makes the communication when he or she does not have a reasonable expectation of privacy or consents to the disclosure of any part of the matter or communication.
Or consents.
How do you define consents?
By not objecting.
And then by what proof do you have that it's made public?
Somebody's trying to bring it in an open court as evidence.
Right. But before they do that, don't they have to give us notice or something like that?
Yes, and they probably already have. But you didn't object, and you didn't hit them with a protective order.
Right. So then.
So you didn't object. You didn't. You don't have a reasonable expectation of privacy.
So your CCI or your CCCI is an objection there.
Well, no. It's protecting the CCI. The objection is really the protective order, which is a cause of action that's going to protect that CCI information from making it public.
Oh, the protective order is the objection. Okay.
Well, the objection is the NOI, and the reason is here it's CCI and needs a protective order.
Okay, I'm confused on that because I thought the UCC1 was the NOI.
So the UCC1 is the claim.
Yeah. Yeah, I understand that.
That is the NOI. That's the claim. Yeah, you're making a claim. That's the NOI.
And the UCC3 is the SOI.
Yeah, now you don't want to put the SOI with that because if you're making them public, other than just a notice of it.
Wait a minute. The UCC is not the SOI, is it, Christian? That is only a record of a transfer.
Well, it's kind of it's a public record pointing to the claim. Let's put it that way. But that NOI, that UCC1 does say, you're claiming the document. It doesn't really state the claim. It points to the claim, but it's like a public NOI that can be seen in the public, pointing to the private actual claim. But what we're doing is we're connecting both realms with some kind of reflection, so that they can act on it.
Now, speaking of public and private, I think it was Terry and I were talking earlier, and Terry's been doing a lot of reading of Article 9/500. And Terry, if you're on, please speak up. But he was talking about, since we're going to be expressing in the private, how much do we need to adhere to some of the rules that 9/500 gives us in terms of filing, and since we're going to do nomenclature changes and utilize these documents for different than debtor-creditor reasons.
Just enough to get it.
I'm sorry, say it again.
Just enough to get it filed. Everything in that UCC says otherwise by agreement. If you get them an agreement to do anything, you can do anything you want.
Well, Christian, this is Terry. I was reading 509, and it was talking about persons entitled to file a record. And one of the requirements were that the debtor authorizes filing.
Okay, that right away tells me it's under debtor-creditor, and we're not doing a UCC debtor-creditor filing. We're doing a non-UCC filing.
So none of that 509 applies to our notices or claims and transfers.
Not as a non-UCC filing.
Okay, gotcha. It's just for notice.
Yeah, we're doing it under Bailey and Baylor, which is a trust.
Baylor, that's another relationship other than trust. That's we got to put.
Mentor trustee.
Yeah, that's why we got to put that in there in that block 7 and put a little check block and block it.
Now, one of the other subjects that I was thinking of that we could have for conversation this evening is when we're thinking about forming these different trust relationships and strategizing for who our trustee is going to be. For example, in a court case, and we're trying to strategize for who the best person to make the trustee is going to be. Is it going to depend on whether it's a criminal case or for example, a mortgage case, or
no? I think it depends on the knowledge of the person and how they feel most competent to handle it.
Okay, because some of the things that we might be concerned about is if we assign, for example, the judge as a trustee, and he disclaims, and the case just hits the wall because nothing happens because he disclaims, and of course we're telling him, let us know when you assign a successor trustee.
But put a disclaimer on there. Put a limitation on the time he's got.
Okay, so if he fails, then he breaches.
Yes, and then tell him so. You've got 30 days to name a successor, or else you become a breach. You're obstructing.
You accept by tacit agreement that you are the trustee.
Well, yeah, you could do that. Yeah.
Okay.
Or get him an agreement that he's obstructing.
Okay, or both.
Obstructing justice, yeah.
Which will generate an action on the public side.
Yeah, get him off the bench.
Okay.
And then if it looks like he's obstructing, hit it with another action and come in with a equity action that you're going to get him with a
unclean hands?
Well, no, not the unclean hands. You're going to prevent him from breaching. You're going to get a preliminary injunction and force him to do it.
Now, another way to look at this is if we didn't want to assign the judge as the trustee because we wanted to continue to give him some power to help us or her to help us, who might be another person to strategize to assign those trustee duties to let's say, for example, a civil suit, for example.
Once you gave the judge it, you pretty much got it. It's just that we're not taking it to the next step. If the guy doesn't appoint somebody after you have specified you got 30 days to do it, if he doesn't do it, you can come back in with another court of equity action against the judge himself forcing him to make an appointment. That's why I keep stressing about we've got the power to prevent a breach from happening through a court of equity, because equity will force him, compel him not to breach the trust.
So, for example, 30 days goes by, he fails, so we would file an action in the colorable side with a new case number. It would be our offensive filing.
Mm-hmm.
And then go ahead and, of course, do another protective order to go into chambers with another judge.
Well, now, this, I might not have to have a protective order on that one, because really this is public knowledge. This guy's fallen down on a breach of appointing a successor trustee, which under a judicial bench setting, he's obstructing, and now he should be removed from the bench, and equity needs to compel him to perform to prevent him from that to happening. It's actually protecting him. He must do his duty.
Now, of course, in Florida here, we got the Good Old Boy Network. What's going to happen when they all start protecting each other in a case like that?
Stick them to the tar baby.
So what you're saying is let them all fall like dominoes?
Yes.
Okay. Just keep filing and filing and filing until finally somebody. So this could, for example, wind up with the provost marshal.
Well, I would eventually start making some public waves out here. I'd start making everybody publicly notice that there's a group of judges down here that aren't acting the way they're supposed to as judges, and they need to be removed from the bench because they're an injustice and they're a fraud upon the court. They're insulting the integrity of the court, of the American judicial system. They need to be removed. Go to oversight. Go to the chief judges. Go higher up. Start making public waves. Have yourself a list of people that are in oversight that'll cause these people grief and pain because they're not doing their jobs. Governors, representatives to the House and Senate, all the people in government. The more waves you start making against that, it's more publicly noticed that you put light on this, what's happening down here, you're going to bring them down. You make public awareness your tool to use against them.
Seems easier to take the root out.
Yeah.
This is Bill. Can I add to that about the trustee? Maybe this might have some strategy benefit under Federal Rule 17. It's called ratification and commencement.
Yeah, I'm aware of it.
Let's say that you receive an offer from an attorney to pay a bill. And would that attorney be one of the elements, one of the real parties in interest, like the trustee, express trust, thereby making him by record trustee, not deny acceptance as trustee?
Ratification. I don't know if I'd want to do it that way or not.
Well, what I'm saying is it just seems that it's here. I think I would express it that way. It's saying that it seems that the trustee under that rule, he's already declared himself a trustee. And so the question really is it having a relationship to an offer we may receive from...
Okay, who has declared themselves to be a trustee and how they declare themselves?
Well, the scope of that rule deals with, representing someone else, but creating an action in their own capacity and or name. So if you will receive a debt collection offer from an attorney for the benefit of, let's say, Citibank, by the fact that the attorney has presented himself in that capacity means that he has capacity implied.
Okay, but that's a trustee on a securitization pool. That's provable. But how's that got to do with your private trust you're trying to enforce as a special deposit that was by the note?
Sorry, I didn't catch that.
Well, the note is what you're trying to collect on or trying to enforce, but that's a private trust that nobody knew anything about. But he's trustee attacking you as plaintiff on a securitized pool. That's public.
Okay.
So we got two different trusts we're talking about.
Right, but he is on record as a trustee.
But for the securitized pool.
Okay, I guess. So we have to be very clear even when we're expressing
what securitized pool have to do with your private trust?
Nothing.
Well, it does, maybe, because it really got to do with your note, but that CCI information, again, how are you going to make that public without waiving it?
I don't want to make it public.
Right. So what's that got to do with Rule 17?
Because the attorney is the trustee. He's already accepted.
Yeah, but on a securitized pool.
Right. I wasn't thinking like it. I think you brought it up. I understand why it doesn't apply.
Yeah. Somehow I'm going to have to tie the two together, and it's going to be kind of difficult to tie the public side without giving them knowledge, and I don't want to do that. So Rule 17, I think, is kind of out.
Okay.
Because if I made it public under Rule 17, I'd have to make a disclosure that, hey, I've got this private trust, that this note's been securitized. They're using my note held in private trust as the security for this public pool, the securitization. Now I'm waiving it.
Not only that, they would take us to the psych evaluation.
Yeah. So.
Okay, gave it a shot. Thanks.
So that generates a pretty interesting question because I'm doing the research to put together a lawsuit to ferret out the different information. For example, how the lender is saying that they lent me money, but I know they reported to the Securities and Exchange Commission during that same quarter that they didn't lend. They reported to them that they didn't lend any money at all. So if that sounds to me like that could bring in this trustee in this with this securitized pool, and then if they're going to say that they lent me money, and I'm going to say, well, bring the note forward to say that you did, then I'm going to go ahead and bring that private CCI, my signature, in a court. So I would be waiving my any ability that private note might give me in that case.
Better off just fighting that cause of action all by itself.
So basically, Christian, what I'm getting is by forming a trust and keeping it private, we have a better chance of it.
That's the only chance you've got of keeping winning.
Right, because if you go to the other side, all the arguments, there's 63 million laws.
Yeah, you've traversed into the case. You're arguing the facts, and you've lost.
Right. So, but on the private side, once they breach, there's prima facie evidence, and they're in position.
I don't want to argue their merits of the case. I want them to argue my merits.
Exactly. So then it's simpler than we're thinking in terms of researching and cases and stuff like that. Because on the private side,
yeah, we're like a bull in a bullfight, and we keep charging the red cape. But we don't know that all we got to do is charge the bullfighter. The bullfighter's dead. We keep on getting tricked and deceived. You keep coming into the case and traversing in the case. You keep charging the red cape. Come on into the court and argue. Traverse right in here on the merits. Yeah.
Well, I guess it's all that conditioning.
Yeah. That's the thing. We've been so brainwashed with these portal word terms to believe just one side, the public side. And here all along, there's been another definition of meaning on the other side, and we've lost that.
That's why we're here.
Christian, do you have any calls where you've done like role play or given examples of a court scenario of how to function the way you're speaking?
No, I haven't. Although we've given some examples on some past shows. Nothing in detail.
Would you consider doing such a thing?
Yeah, if we had time, let's put it that way. But there's only so many hours in a day. Let's put it this way. I'll leave it open for the future. When we get enough people that are up to speed on the basics, and then we can go in and, switch gears and maybe do a more Class 605,
There was someone, was it Jason, who said that he had some samples of the UCC 1 and 3. Is that correct?
Bill, is that you?
Yes, it is, Jason.
So it's Eric, and I'm on Skype at Imagine the numerical number 1.
Oh, well, I'm not Skype savvy, but I'll take that down.
Hey, Christian.
Yeah, Carlos.
Say that again, please.
In a moment, after Carlos gets done.
Go ahead, give him the number.
No, go ahead. I'm sorry.
Bill, it's Imagine the numerical number 1. It's on Skype.
Okay.
I'll share it with you over that.
I can access that with the regular phone?
No, you gotta set yourself. You gotta download Skype, and you gotta set yourself up a username, and then search for me on there. I'm in Florida.
Okay.
Yeah. Yes, sir.
Thank you.
Yeah, go ahead, Carlos.
Yeah, thank you. Christian, I was in a call yesterday. Let's step aside for a little bit. Let's go to banking. There was a banker for 15 years. He was talking about his experience with the banking system. And he said that for 15 years, he got to know the whole system. And when he started asking questions to the CEO, CFO, or COO about note, where does it go, what happens, he got fired. They fired him, and they told him, what are you, they interviewed him, actually. They questioned him, what was he trying to accomplish. He got fired, and he said that as soon as you probably know that. He says as soon as you sign the note and they get their hands on it, they collect 4 times. And that's where I remember, and I told him, well, my brother's note was stamped 4 times. He says yes, they got paid 4 times for the note. And I said, I wonder where's the original one. Well, most likely they got paid 4 times to the original, because my brother has one. Remember the one with the forged signature?
Right.
And also he says what the bank is really trying and what the bank really wants. He doesn't want the property. He wants actually the property back so he can generate notes and more notes and more notes. So that's why you watch it and you never notarize, or they never notarize where your signature is. Therefore, I mean, they can forge it, because I told them about they can do it again. So who knows how many times they cash my brother's note or they forge my brother's.
Yeah, you gave it as an unrestricted signature, not expressing as a special deposit under trust. Because if they would have negotiated it as a negotiable instrument, if you would have claimed it as being a trust, they would have breached the trust. They would have commingled.
Right. And when I asked you if you were go to closing when you buy a home, how would you behave? And is that all you would do when you don't need to do anything else to express your trust or anything else you're going to trust? Just signing ... your name. Is that all you would do on that day?
That would be the minimal I think most people ought to do. Otherwise, if they know how to enforce intent and purpose.
Okay. How would you enforce it on that same city when you're there? I mean, what I'm trying to say, what should you do when you go and sign the documents there?
Well,
half an hour.
Documents should have gone and filed a UCC 1 and 3 and created the evidence of trust.
Right. Yeah. So before we go to closing, we file 1 and 3, obviously.
Yeah.
You can't do that.
No.
You can't do it first. You got to do it after.
That's what he said.
Yeah, not before. Do it after. Yeah.
Okay. I'm sorry. So I misunderstood. I'm sorry, Christian. So let's start over. What would you do at the sitting? Sign your name, ... and what else?
That's all.
That's all. Okay, great.
Then when I walked out of there, go start creating the evidence that I made a special deposit under trust, which would be file a UCC 1 and a 3, say, the next day.
And the bingo is they don't have to know.
As soon as I did that, I would wait, say, 72 hours for the debtor creditor thing to go past, and then I would make a demand for the note back. Order the surrender of the note.
Great. So it is important that you wait 72 hours, right?
Well, for 72 hours, I'm looking at it as debtor creditor point. Yeah.
Yeah, because they're going to wait 72 hours before they put a lien on that property.
Mm-hmm.
They're going to put a lien and become first lien holders on your property after 72 hours by law in California.
Mm-hmm.
So is that what you do? Wait 72 hours?
Yeah, just to play safe on the debtor creditor side, I'd wait 72 hours for that particular purpose.
Okay, great enough, good enough. All right, thank you.
And Carlos, the UCC 1 and 3 is going to be your trust receipt.
Yes, I understand. Great, thank you. And also, Eric, could you send me that document and type that in?
Yeah, just send me a message and I'll send it to you.
There's a question tying into that, Christian. At the closing, could we bring our own notary to notarize the signature?
Yeah, but I don't know if I'd allow you to notarize that note or not.
You don't sign the last. Oh, you sign it, but not out in front of a notary.
No, I was just asking if that would be possible.
What if you demanded it be notarized? That's my question. Or what if you order it be notarized?
Yeah, but then the deal might fall apart.
Wouldn't that be interesting?
See, the point is that California, that's what they do. They don't notarize it, and there's no notarize at the last page, and that's the one when they sell it, they stamp on it. That's the one they stamp on it, the actual note, and they can do a lot of copies.
You could also bring a little pad and do thumbprints or fingerprints on all of them too.
Yeah, I don't care how many copies they make. If they just commingled once, that's all I need.
Yeah.
Mm-hmm.
And if they're coming at you with an action on mortgage foreclosure and it's trustee on a securitized pool, you know on the face of the instrument, it's on the complaint itself, that they've securitized and they've commingled it.
Christian, let's say you go through that process and get your notices filed in UCC 1 and 3. Can you explain the steps that you take from there forward to everyone?
Anybody want to volunteer that information?
Give me a scenario, Mike or Terry.
The mortgage, just like Carlos was talking about. And I'm asking you to do that for the benefit of everyone listening that may not have heard that.
So you would create your trust receipt, so then you would demand or order your note back.
And you do that how? By putting in an order in the court?
Well, you could only put an order in the court if there was a case pending.
Okay. So how do you order the trust property?
Well, you would order through private process.
Through notary presentment.
Okay. What I'm asking for is step-by-step, so everybody listening that may have that scenario, if they have a mortgage that's even up to date now, they can start this process and, settle that account. So what would be the step-by-step process from start to finish? He started that with Carlos's questions.
Well, that's pretty much been explained on a lot of past calls that we've been going on. I don't know if anybody has it written down in a step-by-step fashion, like in a blueprint outline. That needs to be done next.
I think what Terry's getting at is if we could avoid a scenario where they're going to try and drag us into court under creditor debtor. I think that's what he's getting at, but I don't think there's really going to be any way to avoid that if you quit making the payment. And if you quit making the payment, you're not going to have a choice but to go in once they file against you in a judicial state, but to do a protective order and establish your NOI and go into chambers and then use the note to make the payment.
Yeah, I understand all that, but I want the scenario to be that you've closed on the deal and you've expressed your trust and you're making the payments, and then from there on to receiving the title back, what are the exact steps to do that?
Well, there again, it's on a lot of the past shows that we've discussed all this. So it'd be on the past tapes. I don't think one that really explains it is, I want to say a mortgage. Does anybody remember maybe one that we've gone over mortgage more in depth? I can't. my mind to bring out a date that's any particular one.
Well, from my recollection, there's been bits and pieces here and there, and I was just wondering if you could concisely explain, the full process for the benefit of everybody listening.
Well, the bottom line is if you quit making the payment, if you're in a judicial state, they're going to file against you.
No, don't stop making the payment. Continue making the payment.
Well, as long as you keep making the payment, they're going to continue to accept it from you.
Right. So
at what point are you going to quit making the payment? Is my question to you.
That's my question also is, where do you take it into the court system or with notary presentments or what have you that will wake them up to the fact that you're no longer required to make payments and they need to do something?
Okay, you'd have to first ask the bank, or not ask them, demand that the note be back. Order the note back first, then surrender the note. And when they don't surrender the note, then they breach the trust. Now, once you've got the evidence that they breached the trust, you're going to have to take an independent action and come at the bank and sue them under breach of trust.
Okay. And that's all your NOI and SOI and in chambers.
Correct.
Okay, that's what I was looking for.
And in Florida, and Christian, hopefully you can clarify this, but I did some research, and it looks like it costs about $2,500 to file in Florida.
Yeah, for mortgages and stuff, depending on the value of the property, they've jacked the price up, and it's, getting quite expensive now.
And in the federal, I did some research, it's $350.
So this is an example of how they can put such constraints on us to carry out this process of expressing the trust. When you can't afford it, you can't.
However, in Florida, I don't know about Louisiana, Terry, but in Florida, all you got to do is quit paying, and they'll pay to file.
True, and then you're into the potential for foreclosure and all that.
Yeah, then you come back with a counterclaim, and you're back in the same situation now, though.
But then again, what you could do is you could send all your mortgage payments to an escrow company to hold, because once you generate the certificate of dishonor, the fact that they're not producing the note, you have an escrow company hold it. So because maybe you can explain a scenario about that might work with that, Christian, to show good faith to the court, for example.
Yeah, you could make your deposits to an independent notary or something.
Would that be an admission that you owe the payments if you reveal that to the court?
They may construe it that way, yes. But there again, you're in the private chambers. There's where the hammer comes in at their equity, that they breached the trust. They're presumed to be guilty, and where's their record of...
So to be effective in this process, you have to get them to file an action against you, and then you take the defensive
No, not
position.
Really. You can come at them. In fact, that's where the greater power is, really. You could come at them in a court of equity and force them not to breach the trust. Force them to give you the note back. That might be the better route to even go.
That's what I would think.
But again, in Florida, it's going to cost $2,500. In the federal, it's going to cost $350. Correct, Christian?
Yeah, because they jack the prices up on any kind of mortgage action in Florida here. It could be,
and
if your house is cheaper, you got a cheaper price, but it's still kind of be, a couple $1,000 maybe.
Unless somebody on the call has a strategy for suggesting that we can do the filing that we need to do to get the fee waived. I forget what the word paupers in it. I forget what the name of the
David, I talked to somebody about that, and they said that they were a lot of different paperwork to go along with that they couldn't come up with, and then they didn't grant it. So they're always trying to close it down for everything.
Maybe that could be another thing we can work on as a group effort to avoid those fees.
Well, I recall one time is that if you go in there with pieces of silver, that they have to accept it, and then the fee isn't as high because they have to accept the silver. I have to dig that up. I've heard it before. I don't know if it's true, but I'll look into that.
Generally, it's like $20 silver.
Probably 21.
Or maybe 21, yeah.
It is 20. Christian?
Yeah, Carlos.
Yes, when you file for a protective order, and they're going to say, what are you trying to protect? They're going to ask, what are we going to say when we ask for the note back? Or obviously, that's a trust risk, but what are we going to say? What are the contents of the protective order? Or what's going to be inside the protective order? Yes, what would I say?
Well, you would have privately asked the bank or so for the note back.
Yes.
Or you would have ordered the note surrendered, yeah.
Okay, and in court, they're going to ask you, why do you need a protective order? What is it of value that you want to protect?
Well, the CCI information that we're trying to not bring into the public and waive it.
I understand.
There is a private...
How do I explain to them?
I didn't catch it. Go again.
How would I explain to them that, to me, that's very highly important, my trust in there that I'm trying to protect, and I don't want to disclose until I go in private.
Yeah, that's in the protective order. You have to explain why you need a protective order.
Okay, yeah. How would you explain that the trust is so important? I mean, are they going to believe you, or they're going to say that's not something that needs to be protected by a protective order?
Okay, well, JC and Eric, you got anything to add to that?
I don't think JC's on the call, but my simple response, if I was standing in court and they said it's confidential, let's go into chambers and talk about it.
Right. Yeah, but when you file for a protective order, remember, because we were trying to find out about it, Eric, and they're going to ask you what is the content of the protective order? What are you going to have in there that's so highly confidential? What am I going to say so that they don't reject
trade secrets? And this is why you want to get into chamber, and then you explain it.
Okay. I just don't want to be rejected at the first attempt. That's all.
Yeah, you're probably going to have to create a hearing for the protective order, and then in chambers hearing, and you're going to bring in your evidence, why you need it.
Okay. And then in chambers hearing, then I can talk about it all I want, right? Because we're in chambers.
To a degree, yeah. I don't want to give away everything.
Yeah, I don't want to disclose.
Tell them enough.
Yeah, I don't want to disclose my underwear, obviously, right?
Yeah, I just want to tell them enough to get my protective order. You know.
Exactly. Yeah. My goal here is try to get the protective order on the first shot and not be rejected and go back and forth. That's why I'm here trying to clarify the point.
Eric and JC have been doing some, and then there was a fellow up in Massachusetts that was working on that also.
It might have been New York, Christian.
New York? I knew it was up there some. Forget the fellow's name.
I think he was on the call from the 4th of February, I think.
Yeah, he actually had.
Have you done yours?
Yeah, he had success getting a protective order.
Okay. Well,
yeah.
Mark Nass.
Are you the one that has the success in that?
I didn't have the success. I just found the document for the secret. I've been studying the law library the last couple months trying to get it on this trust.
Mm-hmm.
And found the vendors after this one of your calls, and I'll send it over. We put it up on the site and how it looks.
Okay. This is out of O'Connor's Federal Rules, Civil Trials. Some of the section, motion to quash subpoena duces tecum, but under number 5 it says trade secrets. A subpoena requires disclosure of a trade secret or other confidential information. Federal Rules of Civil Procedure, Rule 45, C3, and B1. The movement bears the burden of showing that the information is a trade secret and disclosure would be harmful. And then it lists a case site, 1981. Once a burden has been set by the movement, the party seeking discovery must show that the information is both relevant and necessary. The court must then balance the competing interests to determine whether discovery will be allowed. Another case site. And then discovery denied because deposition notice and subpoena duces tecum were overbroad and inquired into confidential information. The party had not shown its need for the information. So that's a little bit of information there.
Can we expand on that, what you just talked about, Christian?
Okay, sure. Go ahead.
Just read. All right. In a situation where we're responding to a lawsuit, that seems appropriate. But in a situation where we're initiating a lawsuit, that seems like what you just read, we would be on the opposite side of it. So if we were initiating, what would be the how would you mirror that?
Well, let's see. I'd have to have a public cause of action, and then that would have to be showing some kind of, that which would be my NOI, and then my SOI would be the facts to substantiate why we got a breach of trust, say. Call that protective order hearing, bring forth that information, why that should be protected, because it really comes back down to that state secret information, but that still doesn't negate the fact that there was a breach. So I think it really plays out really the same way, except I might have to treat it with a little more activity or action on my side first.
Such as?
Well, I'm the one that's going to have to call the hearing, the protective order hearing, which is something nobody's really mentioned before. You have to call a hearing for a protective order, and that way you got an in-chambers hearing where you can bring in that information and reveal it, and you're not really waiving it.
Or you could simply introduce the motion at a motions hearing.
Yeah, put in a motion for protective order, put in a notice of a hearing for the protective order, set the date for that, do your in-camera hearing, ask for a ruling.
But in the language that you just read, because that was out of O'Connor's, right?
Yeah, that was out of O'Connor's, right.
But what I was really getting at is how would we do the offensive mirror of the language you just read?
I'm trying to read out, is there a particular section that you're having a sticking point with there? Did you remember?
Well, I'm just listening to it, and it really sounds like it's in response. So how would we actually language that if we initiated the action, for example, in terms of a breach? How would we initiate that? How would we language that or would we even use that? Or would we simply do the motion and then notice a hearing and the protective order and just not even use that language if we were offensive?
Well, I would show that the information as trade secret is required because disclosure would be harmful to public policy. it would be a shock on society if they found out that, hey, you can do this stuff.
So again, would you, in an offensive posture, would you just not even use the languaging that you just read?
Well, I would pull out sections of it because what I just said was directly out of that. Okay. I need to show that the information is both relevant and necessary. That's right out of the art that I just read. Then the court must then balance, well, they're going to do that in chambers, the competing interest here to determine whether discovery will be allowed. Then they list that case where discovery was denied because the deposition notice and ducis tecum were overbroad and inquired into the confidential information.
So let's go back to discovery will be allowed. If we're doing an offensive posture, would that even be a concern for us? Because actually we would be the one trying to do discovery on them?
Yeah, what would be trying to discover? Whether or not they made a payment or a disbursement.
So would we want to do a protective order to protect that?
No, I don't think so, because even if they did make a payment or did make a payment, let them produce.
Is that something we want them to produce in the colorable side or in the equity side?
We need the colorable motion, but then if we were going to do a protective order, that's going to have to be in chambers.
No, the fact that they made the payment, would we want to let that come out in the colorable side or in the private side?
I might want to let that come out on the public side. Did they make a payment? I don't know. Can they produce a payment? Did they give them my note back?
Or that they didn't?
Yeah, I don't see how they could produce on a record that they did. I never got one, so I know that they can't produce it, so I really won't have anything to worry about because I know they can't produce it.
And if they did, then right there, everything's done. They have no reason for cause of action anyway against you.
Yeah, but then let's go back to the equity side of the court because equity is going to presume that they didn't. And now it's up to them because the burden of shifted, they're the ones that have to produce. And if they don't produce it, automatically, per equity, you've won. There was that flip-flop because of equity. It's the sides have switched now. It's no longer the movement that has to, everything flip-flop. Different kind of scenario now under equity. That trustee is guilty.
So what you're saying is, for example, if I'm the offensive party, it's my job to prove up the claim on the at-law side.
As beneficiary, making an at-law claim, but really I want to come into equity as beneficiary, making a claim that the trustee didn't make the payment.
So then once I make a prima facie case that they didn't, then it's their job to show that they did. So now it's their job to prove up the claim.
Yes, right.
The black and the white.
Mm-hmm. Yeah, we were now more or less at a law side, and really we should be thinking at equity side.
Now, a couple of the things that I was wondering about. One is that when we sign a citation or anything to do with any court document, and the court takes that and creates a bond off of that, does that make the clerk the broker?
Could, because he's the banker.
So if that makes the clerk the broker, now does that mean that the clerk should be regulated by the SEC?
But that never fly. That's too much truth again.
Okay.
They're sworn in as treasurer of the court. They swear to the judge's counsel.
Yeah, they'll probably never admit to the bonds being in the background. In fact, they may be even in a position they don't even know there's bonds in the background.
Hey, Christian, this is Steve in California. I've got another question.
Steve.
I listened to that January 26th session, and it was pretty good. The part where you talked about title debt and title assets neutralizing towards straw man, if title debts are sent to you, or the way they write your name in either all uppercase or upper and lowercase and all that, it seems like sometimes different notices have different spellings. Does that affect things, or is it still just your signature, the private side? It doesn't matter how it's what they give you. Like sometimes
what's given you is spelled is going to be construed as being the fiction, and they just want your signature on it.
So the title asset is your signature?
Yes, that's trust res. My signature is trust res. That would be the title asset. That's going to be the counter payment or the counter title to the debt, which was the offer they sent me.
So you just remember yourself what's private and public.
Yeah, that's where the knowledge starts coming in clearer when you keep the two sides separate more. And then make sure you put the right kind of hat on which you're trying to accomplish and signing with appropriate qualifier. Trustee, grantor, beneficiary, whichever position you want to play.
Okay, thank you.
Question? Last question.
Carlos, go ahead.
Yeah. Could I compel when I bought my property, right? The trustee was the escrow company, right?
Right.
Could I compel him or could I sue them for my note, or could I express my trust in the note? Could I get him in trouble? That's what I'm trying to say.
Yeah, but what I want to do is maybe revoke the signature on the power of attorney so I can reappoint instead of the trust title company being the trustee, reappoint it to the bank being trustee. Now we got a little different situation, and now we're attacking it a little more closer to home.
Okay.
I got the fire on the bank's roof.
And then do a public notice of the merging of titles?
Yeah, I could, if I wanted to terminate the trust.
Yeah, that's the point. That's our point.
Yeah, but I might want to just say leave the trust there, but demand the note back. If they don't return the note, then they breach the trust, commingle the funds.
Right, going back to 336.
Yeah.
Great.
I think that's causing more problems than the title company who is like, stuck out there in left wings, as being like the scapegoat.
Christian, going back, go ahead, Carlos.
Should we even worry about the perfect wording that they have on the contract on the deed of trust, so that they could trick us into signing and giving away our rights to the cognitive note, because it's so fraudulent.
Once I do a grantor's acceptance on that thing, all that verbiage underneath is worthless.
Okay, so you're not even worried about it,
so to speak.
Okay, you were breaking away. I'm sorry.
It's basically been recontracted over with trust now.
Okay, great. Thanks. Eric.
Christian, going back to 2000 when UCC, the documents we file in the public with the Secretary of State, the UCC documents, how they went from what they were to simply becoming notice filings.
Yeah. Mm-hmm.
What were they before?
Well, it actually was setting up a lien, but now it doesn't set up a lien. It just points to that there could be a lien, and you need to do due diligence and go check it out to other sources.
So now the actual liens would be filed in the county. We would wait our 90 days for it to perfect, and then we would file public notice with the Secretary of State, so we would have something to point to our lien.
Yeah, a lien has to be in the county where the property is, so it attaches to the county, under the property. And a lien.
Stepping over to go ahead.
The lien is just debtor creditor again, so I'm going to think more trust.
Yeah, I was just trying to really understand the difference of what happened in the year 2000 is what I was really after.
They did that for speeding the process up so they could, do more commerce.
So they could create more debt titles.
Mm-hmm.
Okay. And one of the things that you've mentioned a few times in the past, if you could give us a step-by-step, play-by-play on this, with entering into chambers, expressing, and merging titles for dispersion. Once that res is dispersed, let's use, for example, in a simple matter of speeding ticket. They have to disperse to the beneficiary, and by us claiming on public notice that we're the beneficiary, and you in the past had said that they can disperse to an LLC, would we have to give them specific instructions on what and how to do that?
Yeah, how else would they know?
Okay, so for example, give us the instructions about where the funds would come from. Like you said a few minutes ago, they may not even know that bonds are in the background.
That's true.
That they hypothecated with our signature. So, so how would we actually be effective at getting that dispersion?
Well, there is a party. Let's say like the courts would. Maybe that clerk didn't know upon sending the bill for registration in the Treasury that they created bonds, say in the Treasury. They didn't even know or understand that was happening, but the Treasury did. So if I deal with Treasury, they should know, Treasury IRS. It's probably somewhere connected in that master file somewhere, leaving a paper trail somewhere. And I really don't have to worry where it goes, where it's been, as long as, when I claimed it on the UCC-1, if I incorporated all proceeds therefrom, my signature, and those bonds would be proceeding from the signature, those are mine. And I don't really care wherever they are, order them back. Returns, special deposit, along with all the interest. And the interest is really all the stuff that they generated attached to that signature, whatever the amount might be. I mean, you can do discovery on a case that you're trying to get back, and you can start fishing around. And once we find where the trail is laid, where it starts, somewhere there's got to be a paper trail. We could find it if we had to, just by discovery. These bonds are got to be under SEC regulation someplace. Got to be issued out of Chicago, somehow tying in with. Got to be a paper trail somewhere. So if we really wanted to, we probably could dig it up.
Who do you think might be a good bloodhound that could assist us in terms of that hunt?
Well, I think Gene Keating might be a good source to, maybe run it by. He may be able to give us some kind of pointers, I think he's probably checked into some of this stuff, and whoever he uses bloodhounds.
Do you have a way to contact Gene, Christian?
I used to, but I haven't tried to contact him for quite a while.
He's in California.
California?
Yes, I'm going to try to get a hold of Eric.
Okay. So, in order to get them to disperse, we might have to assist the clerks with hunting them down.
Yeah, if you want to collect on the bonds, yeah, you might have to, which is just more work. Okay, anything else, guys?
Yeah, one more thing. So, when we think about banks and we think about the trust side and the private and the public side, which would be the trust side and the creditor-debtor side, what kind of things do we want to look for and say in order to utilize the private side of the bank? For example, I don't know, a local credit union or a national bank. How are we even going to discover that private side is there?
Well, there again, you can't commingle, so I don't think they've got it so compartmentalized that a lot of people don't know one side from the other because they only work on one side, and it's only the higher up guys that do. So So it's the CFOs and the CEOs. Those guys know. Those guys are the ones that you're going to have to bring into court and swear them in and do the depositions from. Before you get to that point, they're going to give you an offer to settle.
Tomorrow night I'm going to dinner with a guy who's an executive at a local bank. And if you have any questions you could suggest for me to ask him, I'll shoot them out there for everybody.
Ask him about special deposits. We talked to a guy that worked for the trust department for 15 years, and he never heard of a special deposit.
According to the banker, only the CEO, CFO, and COO know the real good top secret. Christian, I have a last comment.
Yeah, go ahead, Carlos.
Yeah, I went to court with someone as a translator. I go to court because I need the experience. It's on a foreclosure. And this guy, he's fighting that his home was unlawfully foreclosed. Good enough. And he does have a case still in his home. We went to court, and I translated everything for him. And the judge says, well, this is not the right court to file. You have to go to another court and file a quiet title. Does that make any sense?
What was this court now?
This was just a local court that he filed in California, and it's just a city court. And
That was
it is not the right court.
Yeah, he was probably right. That court didn't have jurisdiction.
Right. Yeah. Right. Now, why would he recommend a quiet title when they already sold his home?
Well, there's a cloud on the title, and a quiet title action removes the cloud.
Okay. So it does make sense to you, right?
Yeah. I want to sue for quiet title action.
All right.
So, Carlos, what kind of action was he in court for when you were translating?
Well, they sold his home at a trustee sale, but they did not sell it. I did a little research, and the bank just sent it over to another trustee. Between quotes, they bought it, and I spoke to the attorney. But anyway, that's beside the point. So we went to court, and because he says, I'm not moving out, and I told him, don't move out, and I did a lease agreement for him, saying that he's been there for many years, for a couple of years already, and he's going to expire in about 2 more years. That'll buy us a little more time. As a renter in California, we have 90 days, so that'll be plenty. Now, he's claiming that it was wrongfully foreclosed, and he says, I need proof, and like they already know. Where's the note? And I says, well, we'll have to go to the right court first, but he had the date already set up, so we went ahead and yeah, sure enough, he says there's no jurisdiction in this court, has filed a quiet title. That's basically it. So we're going to go to court. I have to answer some documents that they have to answer. He didn't answer, and I'm going to do that by Friday. We're going to go next.
So he's already closed, and it's already been sold?
The property has been sold.
Okay, so he's really not under no pressure, really, to,
Right. No, he's selling the home between quotes. I did, like I said, an agreement, rental agreement. So he has 90 days. Basically, as soon as we did that, we bought 90 days.
I would run a debt validation thing with the bank, and then when they fall down on that, generate that certificate from the notary that's going to give you the unclean hands doctrine. That'll give you what you need to come back in and get an injunction and freeze this on an independent action coming at the bank.
Yeah,
then I would come back counterclaim on that one, sue them for breach of trust. But in the meantime, I'm going to demand the note back.
Right, because he did bring it up. I mean, that's all he knew. He's been trying to do his homework, and he says, well, I'm going to ask for the loan. Yeah, well, don't talk too much. Let's go to the right jurisdiction first. And sure enough, and I told him we already did a forensic loan audit, and then we're going to
do a 9-210A4 on him to get the debt validation and come back in and say that it's zero and get that certificate from the notary with the unclean hands.
Okay, even though it has been sold already?
Yes. I mean, he's still in the property, right? He's still got a lease. Yes. He's got 90 days, right?
Yes.
Okay, so within the 90 days, you can eat up 15 days of that for getting this process that you get the dishonor. Once you got the dishonor, now you can go into the court and go into the equity side of the court and ask them to, you're being irreparably harmed, you're being damaged here because of a wrongful foreclosure that's happened, because they haven't validated the debt. And there's your proof that you're being damaged. Then you can get a temporary restraining order or preliminary injunction and freeze this whole thing, and you don't have to worry about 90 days, because now, until this case is heard, you got that much time.
Yeah, and meanwhile, we're waiting for the results of the forensic audit. We're going to add them to the court.
Yeah, you could go ahead and straight litigation, yeah.
Right. Okay, great. I'm glad you brought it up. Thank you.
But you still need the debt validation thing to generate the certificate that you come in with a temporary restraining order, preliminary injunction.
Yeah,
freeze everything.
That's the most important thing right now.
Yeah.
Chris?
Yeah.
Just one quick question here. here. I got a credit card application, and I was wondering if I accepted this on my terms. In other words, if I would go through and I would line out what I don't like and put in what I want, and then sign it as a grantor and return it to them, have I essentially formed a trust now?
Well, if you got the four elements on one of the methods of formation of a trust, yes. But then I don't think they're going to accept your offer to them. If you start crossing out stuff in there, they probably won't accept it.
I did the exact same thing, and they sent me back and denied the card.
Yeah.
Oh, okay.
So what I would probably do is, sign with
been there, done that.
Sign with the ellipsis, get the card first, and then that what you signed was a trust. Make sure you got the proof that you need to prove it was a trust, and then come at them with trust.
Okay. All right. Well, that would be the way to do it then, I guess. Okay.
Yeah, because I don't think we know enough to prevent bringing a breach
right now.
Because
when I know more, I will.
Yeah, because I went over one other time on one of the other shows about the unconscionable contract they're getting everybody to sign, and really they have all these attorneys and things on their side. They have an advantage, and that is antitrust. That's a monopoly. So if you didn't accept your offer, you need to be coming at them with an independent action suing them because they have a monopoly on this. You're at a disadvantage.
Yeah, I know you've covered that before. Yeah.
I have all the causes of action I can share with you guys that he's gone over before. I can do it here in a moment if you guys want to hear them.
Okay.
They're breach of fiduciary duty, breach of trustee, breach of trust, fraudulent transfer, unfair business practices, which underneath that is fraud, misrepresentation, and unconscionable acts or practices against consumers, and unjust enrichment, RICO, antitrust, and then there's commingling of funds and conversion.
But the fact that you couldn't get them to get the card, to get the agreement there, because changed the agreement and made it more of an advantage to you when they're the ones writing the contracts, and they won't accept anything less than you sign their contracts. That's a monopoly.
Yeah, right, and that's where you can get them on antitrust, right?
Yes. They're public entities. They're for serving the public in fairness, and when they come in with unconscionable contracts, that's not fair. And they've got teams of attorneys that supports all this, and they write all these contracts for their benefit.
Right.
The thing is, if you read their contract, it's all favors them. It's absolutely hilarious, and that's what I was reading it, and I just did it for the hell of it. And there were two credit card applications, and I filled them both back and sent them back, and they send them both back to me saying that sorry, at this time we can't give it to you.
Yeah, under the Banker's Handbook, under 19.02, subsection 3, which is opening an account, under paragraph 2, in the middle of the paragraph, it says, these contracts are usually drawn so as to give the bank the maximum protection in the circumstances. But if they are unduly harsh and one-sided, or if they unfairly surprise the customers, or attempt to disclaim responsibility for acting in good faith and with reasonable care, they may not be enforced against the customer. And then it goes on, talking on section 4, unconscionable agreements. It says the well-known rule of law incorporated into the UCC is that between the parties, rule of law can be changed by agreement, and thus the courts in the past have enforced contracts signed by parties that work hardship on one of the signers. Take advantage of the rule, banks and other businesses sometimes have created standard form contracts that give them great advantages and require their customers to waive legal rights. There's your counterclaims, guys. Courts provide relief to customers from such contracts when they find them unduly oppressive or unconscionable, when such contracts are not negotiated by parties with equal bargaining powers and understanding. That's monopoly. And they work a hardship on one of the parties. They may be found to be contracts of adhesion or unconscionable contracts. And under UCC, courts refuse to enforce these contracts against the injured party. But there is no other contract to sign. You guys refuse to give me what I want. Well, I can't even get in a contract with you, and I can't even negotiate the contract or change the contract because you absolutely refuse to grant me anything on the contract. That's a monopoly.
Christian, what were you reading from?
Bank Officer's Handbook, section 19.02, section 3 and 4.
For clarification on a point you made earlier, in a court case, when we send the charging documents back, we would sign the back side, would we not? And which is the private side of those?
No, not necessarily sign the back side. That's debtor-creditor stuff. All I need to do is sign by grantor.
Okay.
What's my will and my... That's the law of the case.
conceptually a district attorney who makes the offer, would that make him then the trustee for your trust? He's making you an offer, and you as a beneficiary?
Well, no, he's sending the trustee the ledgering documents, the receipt, and the bills and things, and
okay,
that's you.
Okay.
Until you come in and change it around.
Okay.
You can make a claim that you're the beneficiary, and that seems to throw the court off a little bit, because now they're claiming that you're the trustee, and you're coming in and saying that you're the beneficiary, but you better have evidence to prove that you are the beneficiary.
As a beneficiary, can you return the documents to them, or strictly as only the trustee, yeah?
Well, yeah, if I'm if they're misconstruing this trust, then I'm the beneficiary, say, and they're the trustee now, then I'm going to return the documents offered as a trust deposit and give it to the trustee, and that's them.
Okay. You do either way.
Yeah, either way you want to play it, you're in a win-win situation. That's the whole thing about this trust. I don't care which way you play this, you got a win-win situation. If you really understand it, you can play either game, either way, as trustee or beneficiary, however you want to do it.
Now, before that, also we're talking about the county, the public side of the county being the holder of property. Because somebody who has the property...
No, they're not the holder. The holder is the one who's in possession, and that's the trustee. That's you. They're the beneficiary. They got equitable interest. They got beneficial title.
So somebody up the line put this into the public trust under the county.
Yeah, you did. You recorded it.
Okay, every time it's recorded, does that start it over again?
Well, it changes the title. It's in trust. It's just changing the title from different offices. Just like Sony and who was it?
Empire State Building.
Yeah, all they did was switch positions on the trustee. No assets transpired. But they made an exchange of trustees, and they effectively, took over the trust of the Empire State Building as payment for whatever it was that Sony was giving the other party.
Yeah, that's a classic.
Yeah.
So somewhere way back up the line under land patent, somebody divided up a large parcel and eventually recorded into the county trust, placed it in the county in the public trust.
Yeah, that's what's holding your land patents from coming forward, because the trust is... the land patent's held in trust.
You said if we merge the titles, we can stop that.
Yes.
How do we merge the title?
With a trust receipt.
Yeah, the merge the titles by the moving titles platform according to NTT, and do the ones and the threes in the counties.
Okay. That'll stop all the property tax and everything else.
Yes.
And any zoning restrictions be eliminated.
Yep.
I like this. This could change society in a very definite way.
Yeah, it could get the government back in the hands of the people.
Oh, yeah.
The government is in the hands of the people. It's just whether or not we choose to take hold of it.
Yeah, well, yeah, you know what I mean.
True, yeah. It's because we're not aware, we don't know, and we don't understand that we are in control. We still are in control.
Yeah, we are the government. We know that. But we haven't been exercising it.
Christian, in that 9-210A4, it doesn't have to be 100 miles long, right? A few sentences is good enough?
Carlos, I have one for you.
Thank you.
Is that the one I sent you?
No, it's one I created.
You might want to compare the one I did.
I think I did. I included the order for death validation, a power of attorney, and a cease and desist in the same document.
Okay. Eric, can I get both, please?
Yeah, they're all in one. I'll send it to you. Just send me a Skype.
Yes.
Share something with you.
Go ahead.
I was looking through the Internal Revenue Manual, and I found this. Bankruptcy estate returns are submitted only by the fiduciary trustee of a bankruptcy to individual involved in bankruptcy. Either Chapter 7 or 11 of Title 11 United States Code. A Form 1040 is required to determine the estate's correct income tax. But you've been saying all along about the 1040 putting as the trustee.
Yeah, yes.
I believe that the manual that's what it just read right there. That's it. Hello?
Yes.
Can you hear me?
Yes, I can hear you. What was the question again?
No, I was reading off where in the Internal Revenue Manual is stipulated that the 1040 is a bankruptcy estate is only submitted by fiduciaries/trustees of a bankruptcy estate.
Mm-hmm. So we appointed ourselves trustees?
Yes, basically what you've been saying. And then I think on Saturday you had mentioned something about EIN for the foreign trust would be 98.
Yes, correct.
So I want the applications for entities signed EIN C698 are only processed by the Philadelphia International Unit.
Mm-hmm. Where all the non-resident aliens are, where they have to file.
Right. And then the last thing is non-negotiable remittances.
Non-negotiable what?
Remittances.
Correct, yeah. Remittances.
If you form 1040, other correspondence is received with a non-negotiable remittance.
Non-negotiable remittance?
Yeah, non-negotiable.
Okay.
Is
do. I remember I spoke to you before about this, and I couldn't print it, but the non-negotiable was a 1040X.
Okay, say that again. The 1040X is a non-negotiable instrument?
Yes, it's used for non-negotiable remittances.
Ah.
And it also says it's the claim system.
Oh, that's interesting. Yeah.
Sir, what section are you reading both of those things out of? Please share that with us.
Which one would you like?
Well, the first one and then the second one, what sections were they coming out of?
The first one was about the bankruptcy form 1040.
Yeah, that points us as trustees. What is that from, and what?
That is from the Internal Revenue Manual.
And what section from the manual is that in?
3.11.14.8.2.2.
And then the thing about the 1040X, what section is that from, sir?
21.5.3.4.16.15.
Was the first number 21?
Yes.
Drop that for a moment.
Well, it looks like they forwarded to different places. Me being in Mass, my site would be Andover. They forward 1040X form to the President's submission practice, and then Memphis would go to Fresno as well. If it was Philadelphia, it would go to City.
Would go where?
Kansas City. Kansas.
So can we glean from what he just talked about that once we correct our IMF and we want to, obviously we won't have any taxable liability as long as we don't commingle, but if we wanted to set up, for example, a charitable trust to have some activity here for whatever reason, where could we use that 1040X in that situation?
Oh, that takes some more research, I'd say. To make sure you weren't commingling when you try to do something like that.
Okay, Christian, we are most grateful for your teaching and your research, and we hold you in great esteem. And it sounds like you have to run out of gas.
Well, yeah, it's late. It's 1:30, so.
Anyway, we're most grateful. Thank you.
All right, any other questions? Closing?
Well, one thing is, for example, when we accept presentments from the post office, for example, a certified mail ticket or a Form 3849, a delivery notice for you to go to the post office and pick something up, and then you go in there and you got something you got to sign, it would always be a good idea to, for example, use an ellipsis, for example, if it's a presentment that we're not aware of before we open the envelope, in order to establish from the initial accepting of the presentment, right?
Right. That's a qualifier of, that most people aren't going to recognize. They're not going to say too much about, 3 dots being before your name. You could easily just, blow that off. You could say, well, that's just the way I sign. That's got to have it. Yeah, that's
how they got Jaime.
They got what?
That's how they got Jaime. They were looking for him, and they wanted him to sign something so they could throw him out of the house. They sent him a letter. He had to go sign for it, and as soon as he signed for it, so if he had signed that, maybe that could help.
Yeah, because that's signifying something's missing there.
Right, because he told me, they could not get a hold of me, and they posted stuff on the notice on the window door, and they could not get me to sign, or someone over 18 to sign. They sent me something over the mail. I wasn't here, and I had to go pick it up at the post office, and I signed for it. So if he had signed that, maybe that could have helped me, maybe?
Yeah, because you could express it as a trust from there, if you knew it was trust and it had been under debt or creditor. Okay, anything else?
No, thanks not for me. Thanks so much, Christian, for all your time.
Okay. Well, good night, all.
Probably have a lot more, but not tonight.
All right. Tomorrow at 8 o'clock.
Night.
Right. Night.
Okay. Thank you, Christian.